Tēnā koutou katoa. Welcome back for day 2 of the hearing stream B1 and B2 for the proposed Timaru District Plan. This morning we begin with a submission from Helicopters South Canterbury, Mr. Geary.
Morning, so I'm Richard Geary, owner-operator of Helicopters South Canterbury. I assume you've already had a statement and submission. Their submission is really in line with NZAAA and the NZHA, which those two guys spoke yesterday. So really I just want to put a bit of background to who we are and what a restrictive plan could do to us. So we're predominantly ag, so we do a lot of spraying and spreading, and that encroaches to the lifestyles of the world. I put in my submission there that when we're spraying, we might be taking off up to 10 times an hour, so not 10 times in a week or in 30 days. So if the plan was how it was originally set out, we wouldn't be able to do business in a lot of, like for our ag business, and look after our primary producers. So from major vegetable growers to just sheep and beef farmers, dairy farmers, horticultural. We do frost mitigation as well. So if it was restrictive, we currently operate 4 machines. We would have to shrink our business, which would mean less employees and would have less capacity. So in here we do a lot of work for government agencies. So we work for DOC, we work for ECAM, we work for Foreign Emergency, we do civil defence work, we do search and rescue. So basically what I'm saying is if we shrunk our business, our bigger machines that do the firefighting and the search and rescue would probably lose because we wouldn't have the capacity to sustain those helicopters or the finite economics of it. So like that's basically all I really want to say is just we're fully in line with Andrew's recommendation, like what he said, like makes a lot of sense. It's I haven't got a lot more to say.
Thank you, Mr. Geary. Just to be clear, so you are comfortable with the amendments proposed?
Yes, yep. There's a couple there that the NZAAA were wanting to reword, but a lot of what Andrew's put in his report is quite logical, yep.
And you think it's practical?
And practical, yep. Yep, like obviously with a few different wordings, like fully in line with the AAA's stuff, but I think what Andrew's compiled is, quite logical for go forward. Yep.
Right, I'll just check with the other panel members to see if there's a question.
Thank you, Mr. Geary. No questions as such. Your presentation today has been really clear, you should be really pleased with the process in terms of your input, and obviously you're comfortable with the Section 42A regs. So that's it's good to hear, and we'll be thinking very carefully about the issues you've raised.
Yeah, thank you.
Yeah, thank you.
Thanks, Rich.
Mr. Moore, your group of clients.
Good morning, Commissioners. My name's Philip Moore, Legal Counsel for 2 submitters here this morning. In the first instance, the Aircraft Owners and Pilots Association of New Zealand, and secondly for Sid Macaulay. In terms of who's sitting up here with me, I have Emma Pearman to my left, who is legal counsel working with me. Immediately to my right, John Evans for the Aircraft Owners and Pilots Association, and Sid Macaulay. I will call up two additional witnesses as the case is presented this morning. So, in terms of the case this morning, I've filed some legal submissions. I understand that those have been read, so I don't intend to take you through them. What I will do, though, by way of opening, is to step through at a high level what the case is for the submitters that I'm representing. I'll then transition into the recommendations that have evolved a little from the Section 42A report. I have had an opportunity to consider Mr McLennan's response to the questions that were asked yesterday and the further supplementary written material. I will engage in that after I've provided the summary of the case. So in terms of the activity that is the interest of these submitters, it is the operation of non-commercial small fixed-wing aircraft in the rural zone. You will see from the relief that has been filed that a definition has been proposed for non-commercial small fixed-wing aircraft to provide some certainty about precisely what type of aircraft are covered and the aircraft that are of concern to these submitters. The issue that has arisen in the context of the proposed plan is the restriction on the flying of those aircraft throughout the Timaru district within the rural zone. The issue that's arisen is that restrictions are proposed for the activity in a way that differs from the restrictions that have applied in the past. In particular, the rule GRUZ 14 is of concern. That is the rule that, as notified, sought to introduce restrictions by way of a limit on aircraft movement together with a setback in terms of the operation of airstrips in the rural zone. The proposed plan represented a change from the status quo not regulating the activity. That raises quite an interesting question in my mind, at least, about what is the effect to be managed in the context here. A careful reading of the material that was put forward in support of the plan, and by that I mean the supporting technical documents underpinning the Section 32 analysis and the Section 32 analysis itself, do not highlight or identify any effect whatsoever or any issue at all associated with this particular activity. When I say this activity, I'm specifically referring to the non-commercial operation of small fixed-wing aircraft. So we have a situation here where there's no evidence of there being an issue, there's no evidence of an effect that needs to be managed. And from a technical planning perspective, there's no assessment whatsoever in the Section 32 report about the restriction or the imposition of a restriction on this activity. And so it's been somewhat difficult to understand precisely what the problem is that this plan is seeking to work on in this instance. Our clients have made some inquiries as this plan has developed. They've made inquiries of the council through a series of Lagoima requests, again trying to understand what it is, the issue that the council is concerned about. And perhaps paraphrasing those requests, the interest was perhaps there'd been complaints about this activity, perhaps there was an unknown consequence that had been occurring. But the response to those Lagoima requests confirms what we now understand, that there is no identified issue, no complaints about this type of activity have been lodged. And so the proposed plan and its restrictions are not in response to a known issue. And so again, we're left with a situation where impositions or restrictions on an activity are being proposed to solve a problem that in my submission doesn't actually exist here in the Timaru district. So what to do about that? The solution that has been put forward by my clients, and you'll see attached to the legal submissions, is providing an exemption for this particular activity, so exempting the operation of non-commercial small fixed-wing aircraft from the restrictions that had been put forward in the rule. And as I noted in opening, a definition to go with that, just to make sure that there's real clarity about what aircraft movement are indeed the subject of the exemption. I turn now to the Section 42A summary statement. So in response to the evidence that was filed and the legal submissions, the 42A reporting officer has further considered this issue, and we are, in my submission, 2/3 of the way where, or towards the outcome that my clients are seeking. So there's, as I understand it, an acknowledgement that the restrictions on the number of movements are unjustified and therefore no longer recommended. The recommendation from the officer has also evolved such that the setbacks that were included within the rule are no longer being recommended. However, what was left potentially as a live issue was a suggestion that the matter to be worked on here was apparently the issue of noise coming from this activity, and that there should still be some restriction in relation to the noise and some control in the plan dealing with the noise. Now, that is a somewhat challenging position to be being advanced at this particular juncture in the context of the plan. And I say that because there's no evidence that this activity is creating a noise effect that requires any regulation whatsoever. The second submission I'd make is that there's no clear recommendation from the officer about what that restriction looks like. A question was put to the officer yesterday that perhaps the existing noise standards that are referred to in noise R1 might be appropriate, and from listening to the answer, I was left with the impression that the officer was not perhaps across the detail of those noise standards. Now, I don't say that to be critical. It's a reflection of the fact there's no acoustic evidence from a qualified noise expert saying that the two standards referred to in the rule actually are appropriate for managing this activity. There is a challenge in terms of looking at those standards. They're not available in terms of documents. I couldn't see them in the pack of documents to be incorporated by reference. And so I was unable to even look at the documents to see how they might apply in the context of this activity. But the submission I make is that because there's no technical evidence before the panel supporting that rule, there's no evidential foundation for the imposition of such a rule should the officer look to recommend that. The second submission I make about the potential imposition of a noise rule is that there is a clear scope issue for bringing that type of additional restriction in at this juncture. In terms of scope, the starting position is the plan is notified. That plan had a clear exemption for this activity from the noise rules, and so the bookend in terms of scope does not extend to allowing the imposition of this type of a noise rule on the activity. We then look at submissions that have been lodged and ask the question, are there any submissions that would give the panel scope to impose this type of restriction? From my analysis of the submissions, I couldn't see a submission seeking the imposition of a noise rule overlaid with GRUZ 14. And so the submission I make is that even if the officer were to recommend the imposition of a noise rule without any technical evidential foundation, there is a legal issue in terms of scope for imposing that type of restriction on the activity at this juncture. So where does that leave us? It leaves us with the position that the evidence before the panel is the evidence that you'll hear from the witnesses this morning. They'll tell you about the activity. They'll explain how the activity is undertaken in practice. They'll explain that as far as they're aware, there have been no complaints lodged about this activity. To the best of their knowledge, there's not a problem that this plan needs to work on. And when we go back to looking at the fundamental question under section 32 about the appropriateness of restrictions with respect to these types of activities, we're left with no evidence of a problem, and the only logical outcome here is an outcome where the type of restriction that has been put forward in the plan is simply not warranted in this context. The final submission I'd make before I hand over to those witnesses relates to a potential issue as to whether there's a regulatory lacuna here if there is indeed an issue to be resolved. So if the issue is indeed noise, is there any ultimate regulatory backup here in terms of noise from this activity? The submission I'd make is that the RMA does indeed have that regulatory backstop in section 16 in terms of unreasonable noise. Now, when there's a known noise issue, it's probably inappropriate to be looking at section 16 as being the response to that. But in this situation where there's no evidence of an issue, where there's no evidence of complaints about noise here, it does, in my submission, perhaps provide a layer of regulatory comfort that there is ultimately a response, if there did need to be a response to a noise issue in the future, if circumstances did change, and that is the only backup that is required in this context. So those are my opening submissions. I'm happy to answer any questions from my opening or my written legal submissions ahead of handing over to the witnesses, or I'm happy to circle back at the end of the presentation and answer any questions.
Thank you, Mr. Moore. I just need just a question in relation to if there is scope to consider an alternative to default effectively to the noise rules in the plan, and I hear what you're saying about potential scope issues there, but had you given any thought in terms of a section 32 analysis, whether such rule is effective or efficient in the context of the type of noise being generated by this activity? Did you have any thoughts on that?
Well, in relation to the section 32 report, there simply isn't any assessment of the noise from this particular activity. And so that underpins the first limb of my submission, that there's no evidential foundation for the imposition of a restriction. And when you come to ask yourself the question of appropriateness under section 32, there's no evidential foundation for you to make the assessment that a restriction is required. And so if we unpick section 32 and ask the question, is it efficient, is it effective to impose this restriction, even a noise restriction? My submission is that the answer is no, because there's no evidence there to get to that point.
And just in terms of the, hypothetically, if we got to that point, did you have any or want to make any comment in terms of the enforceability of such a rule in relation to the non-commercial activities?
Yeah, two submissions there. Number one, without actually being able to analyse the noise standards because one can't read them, very difficult to see how they would apply. Reflecting back on cases where I have in the past had to look at those standards, they are quite often specific about the types of noise that they're monitoring. My recollection from dealing with cases involving sound from the likes of commercial airports is there needs to be a bespoke system for how you measure noise from this particular activity, and that needs to be given quite some thought because the noise that might be generated differs, for example, from an industrial activity or a steady state noise activity. And so we're left here in a situation where we have no clarity at all as to what a standard might need to look like to regulate the activity. Which brings me back to the submission that we have no evidential foundation for the imposition of such a restriction.
And also just a point of clarification, in terms of the Lagoima requests that were made to the council, I wasn't clear whether or not the council had simply failed to respond to the request about complaints or monitoring, or the response was that there is no such information.
That's probably a question best directed to Mr Evans, who made the request. So if I can just hold that, if he's unable to answer it, I'll circle back and answer that once he's closed. I'll go back and read the response.
Thank you.
Mr Moore, at your paragraph 11, I understand what the issue is, but I can't relate the words to the issue. Sterilising ancestral. What did you mean by that? And remember, I'm not a lawyer.
Right, so the underlying point that's being made here is that the activities that have been occurring on land here in the rural zone for quite some time, this rule seeks to put an imposition on those activities in a way that's different to what's happened in the past. The use of the word sterilising, or the phrase sterilising ancestral land is some interesting wording here, but the underlying point here is one of change to the activity, and that's what that paragraph is getting at.
Right, thank you.
Sorry, getting used to these microphones again. Mr Moore, you can call your first witness.
Thank you. The first witness I'll call is Mr Evans, and Mr Evans has filed a short brief of evidence and has prepared a summary as well. So I will hand over to Mr Evans. You'll need to switch your microphone on. The floor is yours.
Thank you, Mr Moore, and good morning, Commissioners. My name is John Evans. I am a farmer based in both the Timaru and the Waimate districts. I'm also the South Island representative of the Aircraft Owners and Pilots Association in New Zealand, and we represent within this submission the interests of the Sport Aircraft Association, the Cessna 180-185 group, and others who will talk soon represent another good portion, and I believe within this room we probably represent over 90% of recreational aircraft activity in New Zealand. I'm opposed to the restrictions imposed on non-commercial fixed-wing aircraft through General Rural Zone Provision R14. Further, I do not consider the changes in the Section 42A report adequately address the issues raised. This is despite a significant contribution by way of submissions from those in our community taking issue with our council's impositions on our activity. My airstrip is used on an as-required basis by myself and friends, including for training and also fertiliser application, which includes the use of aircraft from Mr Geary, who you've just heard from. The level of activity on the airstrip depends on the weather, farming activity and other time commitments. The number of private aircraft has remained steady over the decades within the Timaru district and including in New Zealand, as has the number of private recreational airstrips. There has been no increase, to my knowledge, in the scale, intensity of activity in respect of private recreational aircraft or airstrips. Therefore, there is no need or justification to increase the regulations in this area. Further, there is no evidence of there ever having been an issue with aircraft noise in Timaru, let alone non-commercial small fixed-wing aircraft. Aviation is already heavily regulated by the CAA, and I elaborated on some of that detail in my written statement, my written evidence, which imposes various limits on pilots for, above all else, safety. Aviation is also obviously highly limited by weather and daylight. This naturally restricts how often and when we can fly, further making a sudden major increase in activity unlikely. I made a legitimate request with the Council to try and get more information on the basis for imposing the restrictions of R14. I outlined the full request and response in my evidence that was provided. However, in summary, there were no complaints of any information which showed small fixed-wing aircraft were causing an indemnity issue. To answer Mr Moore, or the question directed to Mr Moore, I did not go back to the Council and seek clarification that they could collect the data or whether they'd actually looked hard enough to find it. So the onus was on the Council to provide that and let me know if they didn't have that information, which they did not.
Right, just to be clear, so did they say there is no information, or did they just not respond to your request?
They didn't respond to my request to provide it. I did receive some information in response to my request. This was information containing email communications between the planner and the external consultants discussing the rule. The planner and consultant were discussing a substantially higher movement limit that was proposed, and that changed and turned and fro. It is unclear why the movement limit was reduced to what was finally arrived at in the notified proposed district plan. The planner and consultant also discussed separating regulations related to airstrip from helicopter landings, as they are different, very different types of noise. These discussions are not reflected in GRZR 14, but make sense as fixed wing and rotary wing aircraft create different noises, and per the planning standards, NZS 6805 and 6807, helicopters are spelled out as containing special audible characteristics, hence they are treated differently. On the noise topic, I've just got this example to present. Imposing a 500 metre setback to Timaru Airport, grass 1129, which is the airstrip used for recreational use, on top of the existing out-of-control boundary, where it is contained within the airstrip itself. So how the NZ 6805 is applied as a noise contour, if you look at the planning maps for the Timaru Airport, the contour where those noise-sensitive activities do not need controlling outside of is contained within the airstrip itself. If we then impose a 500 metre setback, that is an area of 180 hectares of land to require that this indemnity effect is managed. Furthermore, in the Section 42 report, a 1,000 metre setback is an area of 520 hectares. Within that 520 hectares, not one single noise-sensitive activity could exist. Our farm is 1,100 hectares, and we only just fit that exclusion zone on our property owing to the geometry. We are talking an airstrip that is used recreationally at most daily, often just weekly or monthly, and Timaru Airport has several thousand annual movements just on that grass 1129 vector. This example demonstrates such poorly considered policy not based on need or assessment. In summary, basically, if you would apply NZS 6805, which is the planning standard used at an airport, for the type of activity we're talking, there is no setback required because the noise contour of 55 decibels LDN is contained within the extent of the airstrip. Imposing GRUZ R14 would have significant negative impacts on the region, including reducing the ability for students to train in non-airport environments, reduced support of conservation and biosecurity, which ties in with what Mr. Geary was talking to, reduced places to land, which can be problematic in an emergency. I've got friends in this district who have known airstrips, and if there's an issue, the helicopter pilots with Heliotago or Christchurch helicopters know he's got an airstrip there, they know it's clear of power wires, it's got a windsock, and he's got pictures of them landing on it. R14 will limit aircraft being used as a legitimate mode of transport, which in my case is a legal way for me to get from A to B to undertake my recreational activity and other things. It reduces recreational value for aviators and subject landowners to legal and financial burdens to either apply for a resource consent or establish existing use rights. While existing use rights do apply under Section 139 of the Resource Management Act, no one in our district is probably going to voluntarily get one unless they need to. That need would arise because you've potentially got a neighbour or the council saying legitimise your activity. In that case, as an individual such as myself, I'd probably be going up against lawyers who are defending or acting against my interests. There's plenty of case law out there. I can give one example of Araroa, which is contained in the Abel Tasman region. They had to legitimise that private airstrip on freehold land through Section RMA 139. Because they had a fight on their hands with the Tasman District Council, they had to go through courts, they had to go to rest homes to get pilots' recollections of their number of landings they'd done and whatnot. It went on, it cost several $100,000 in legal fees. Eventually they got it, but the point being, if you need to legitimise it through that pathway, it can be very expensive, especially when you've got to have that activity continuous within a year. That can be problematic if people are out of the action for a year, or it just opens up an unnecessary burden. GRUZR14 imposes unnecessary restriction on the Timaru District aviation community, despite there having been no evidence of any issue with this activity in the past. Finally, I seek that non-commercial small fixed-wing aircraft to be excluded from the setback and movement limits of GRUZR14. Thank you.
Panel questions, thank you.
No, thank you.
I don't really have a question. I just wanted to acknowledge the submitters within the space, and I think we can acknowledge that there seems to be discrepancies, and so we will definitely be seeking evidence that you've discussed. So, yeah, just want to acknowledge Mr. Macaulay and yourself, Mr. Evans, for, you know, probably quite a stressful time for you all. So I just wanted to acknowledge that, and you will be looking very deeply into this particular area.
Thank you, Mr. Evans. I was interested at paragraph 15 of your written evidence statement. You mentioned the contrast between the Waiheke Island situation in Auckland Council and Te Maru. So I was interested, just for my own understanding and context, the differences in the scale of the activities between those two places. What's your understanding of the situation in Waiheke Island and the Auckland Council regulations?
It was to point out that is a very public environment there. There's been a lot of, well, there's obviously a lot of wealth, and typically this applies to the use of private helicopters to access their land on Waiheke. We've distanced ourselves from that issue twofold. The first one is that that type of issue hasn't seemed to have occurred in Timaru. There doesn't seem to be that level of wealth that people are flying around in private helicopters. The second is that the scope of our evidence is to small fixed-wing private aircraft. Typically, they have an increase, as a private aircraft, they have increased social licence versus helicopters in the Waiheke Island setting. Does that answer your question?
That's very helpful, thank you. And just to note that I've found your presentation today very helpful as well. Thank you.
Mr. Evans, can I just ask, just as a pilot, are there any other regulations that apply to you or your activities that require you to keep records of your flights, flying hours, frequency of flights?
Yes, so it's a requirement under the Civil Aviation Act that we record every flight and locations and details like that. I know where this is going. There's been a lot of district plans around the place that have said that, you know, you need to provide records to the council. There's typically been pushback. I think that was within the plan proposed with Selwyn. I don't believe it went through, but don't quote me. It's just another extra thing that I don't feel I have to disclose to the council. It's like saying, oh, you need a record every time you took your car out of your garage, or every time you cut firewood, or every time your kid went and played on his motorbike in your paddock. I mean, addressing back to the point of our argument that Mr. Moore has highlighted is that we don't want to overcomplicate an issue that we don't believe exists.
That responds, I guess, to the issue of frequency of flights, but what about in terms of the maintenance of aircraft and ensuring that engines, etc., operate efficiently and up to spec?
So aviation, as you can probably appreciate it, is the highestly regulated activity in New Zealand. Every aircraft is on a maintenance program. Every aircraft is signed off to legally fly. every aircraft has a maintenance schedule and a maintenance procedures. Some aircraft are certified to higher standards than others. For example, in New Zealand, aircraft operate on a very different certification basis, but still there's no ability for me to simply strap a car engine to my home built and take off on my paddock like that. You could do that, but it does go through a certification process. So, and furthermore, if there's any incidents or accidents, they have to be reported to the Civil Aviation Authority. That's a statutory requirement. Without having, if you don't have a specific knowledge of the aviation sector, if I started going on about how regulated we are, I think your eyes would water.
I guess we probably have more familiarity with regulation of airports and airport activities, but I was just trying to understand how it might apply to non-commercial and private operated airstrips.
Mm-hmm.
Thank you. No further questions for me.
Thank you.
I thought we might go next to Mr. Sinclair, who I understand is online.
Hi there, how are you?
Good, we can hear you loud and
Can you
clear.
hear me okay?
Yes, can you hear us okay?
Yeah, good as gold, thank you.
Right, you could proceed just with your summary of your evidence and answer any questions that the panel has.
No problem. Hi panel, again. I spoke with you yesterday, as you might recall. I'll perhaps start from point 3 of my submission. My introduction seems a little bit unneeded. I've been living at my current address since October 1990, and I've owned and operated an aircraft that entire time. I selected this property because the quality of the potential airstrip, which I then developed, re-fenced and prepared the surface. The zoning of my property is R1 under the operative district plan. I built a hangar on the property, which has a building permit. The Timaru District Council corresponded with me at that time, and I indicated that my airstrip was for private use and that I would not be conducting any commercial operations on it, not running any business or anything like that. And we discussed the fact that that would need a resource consent if that's the case, which it's not. My airstrip serves my private needs, is used for flight training to allow pilots to experience landing in a non-airfield environment as a weather or unplanned precautionary safety alternative, which is a really important thing for pilots, and a stop for others to use so that my pilot friends can visit, and we sometimes have organised social gatherings at airstrips, including mine. My airstrip is occasionally used by aircraft doing agricultural work, usually applying to my farm, but not always. Sometimes it's for neighbours, and it's been used for gifted flights for local fundraising efforts for the community. In the nearly 34 years I've operated my airstrip, I've not had a single complaint from a neighbour or a member of the public. The council has never visited my airstrip. My neighbours are genuinely interested in my flying activity, and I've taken most of them for a flight, and in fact they sometimes complain that my windsock is currently broken and they would like to be able to see the wind. My airstrip is located 200 metres from a neighbouring household. Despite this, no complainant has ever been received. It's worth noting that that house has been rented to many different parties. I think in the whole time that I've lived there, there might have been as many as 15 different tenants with all different outlooks and viewpoints, and not a single one of them's raised an issue with it. The restrictions within RUS R14 of the proposed district plan will mean that the continuation of my flying activities will either require an existing use certificate at significant cost to me financially and in time. My flying activity creates a noise profile that is significantly less than many of the day-to-day farming operations that are likely and rightfully allowed to be conducted on any day of the week, with those farming operations often occurring at times of the day that may be considered to be unsociable and affect amenity, and we talked at length about that yesterday. There is no basis for RUS R14 as proposed to be included within the proposed district plan, as there is no evidence of a problem to fix that needs solving. with respect to use of small fixed-wing aircraft on private airstrips. I'm opposed to GRAS R14 as proposed in the proposed district plan and request that it is deleted or modified to allow recreational and private plane use to be unlimited. I'm not aware of there ever having been an issue with the Timaru district regarding how small fixed-wing aircraft on permanent airstrips are used. I personally have never received a noise complaint or any complaints about my flying or use of the airstrip. GRAS 14 will impose unnecessary regulation on the activities of small fixed-wing aircraft and associated activities, despite no evidence of them having caused noise or amenity issues within the Timaru district. I seek for the flying of small fixed-wing aircraft on permanent or non-permanent airstrips to be a permitted activity without restrictions. As to the frequency of takeoffs or landings or setbacks, and for the small fixed-wing aircraft to be excluded from the provisions of GRAS R14. So, yeah, that's my submission. If you have any questions, I'll just flip back so I can see you.
Thank you, Mr. Sinclair. Just acknowledge that we heard from you yesterday as well and have taken on board what has been said both yesterday and today. I don't have any questions for you.
I might just have one. How many people in the Timaru district have fixed-winged aircrafts?
Not sure, I might have to get John to help me there, but I would say personally owned aircraft of fixed-wing variety, I think I'd be estimating somewhere in the region of 30 to 40. John and Grant may be able to add to that. What are your thoughts?
Somewhere in the region, a lot of them are based out at either Rangataru Island, who you'll hear from Russell. Some are based at airports, some are based at airstrips. One of the points we've made, there are a number when you add them all up. And there's probably more than the general public realise because they go unnoticed. People don't know they're there, they operate, and then that's why we're sitting here arguing.
Thanks, John.
Thank you, Mr. Sinclair. There are no further questions.
Okay, thank you. I appreciate having the opportunity to talk to you today again.
Thank you. We'll now move to the next witness, Mr. Macaulay.
Good morning, Commissioners. My name's Sydney George Macaulay. I'm a company director and I reside on a 270-acre farm in the Timaru district, which is operated by a commercial farmer, and in fact the farm is on the boundary of the township. I'm opposed to restrictions being imposed on non-commercial small fixed-wing aircraft through the GRAS R14. I do not consider the changes in the S42A report adequately address the issues raised. I've flown in the Timaru district for many years. I've never received any complaints, nor am I aware of anyone receiving a complaint about the noise of non-commercial fixed-wing aircraft when taking off or landing. I have many friends who fly, and I think the question was asked about how many aircraft in South Canterbury. I think when everyone put their heads down and starts writing down aircraft, there's probably in excess of 50 aircraft, I would say at least, in the Timaru district. I'm a member of the AOPA that John Evans here is representing. Also a member of Dad's Air Force at the Timaru Airport, of people who operate planes there. We all land on strips around the district. We socialise regularly. I've never heard of anyone having had a complaint about the aircraft movements. And on our farm over the years, we have fixed-wing aircraft spraying crops. Mr. Geary sprays crops for the farmer from time to time. It's within a couple of 100 metres of townhouses, we don't get complaints. We get people saying how great it was to see the planes operating. So I think the council's looking for a problem that doesn't exist. In fact, it's the reverse. The people of the district enjoy seeing light aircraft, and when often we will have a fly-in at a friend's place at a weekend, and if neighbours become aware that there's aircraft coming, they come to watch the activity. They appreciate the aircraft. They're not opposed to the aircraft. That's our real-world experience. So the imposition of the R14 will mean many rural airstrips require consent or cannot operate despite no issues having been identified. And the GRUS R14 would limit our ability to recreational fly and reduce the ability to practice safe takeoff and landings in case of an emergency. And this is really the key. All of us who fly light aircraft have to practice regularly forced landings, landing at farm strips like Mr. Evans's or many other farms around the district, and we don't necessarily even land on the strips, we just land on a paddock. And if we're going to have an engine out, it's highly unlikely to be above the Christchurch Airport. It's bound to be above, if we're lucky, a paddock. And to comply and keep current with our licences, we have a responsibility to practice these things. And the sort of impositions you people are talking about is in fact going to impact on the safety of pilots by causing unnecessary restrictions for them to keep their flying current, because the questions were asked about the regulations and do we have logbooks with our flying, and we also have to every 2 years have a biennial flight review, which is redoing the flight test. So I can assure you just about every pilot out there operates safely. His aircraft has to be serviced by a licensed engineer every 50 hours, 100 hours, 200 hours, or 1 year or 2 year. It's a very safe activity, and I think best left to our own activity, which has been operating in this area probably since aircraft have been about. We have Richard Pearce. I first flew with a chap called Sid Lister, who was an iconic pilot here in the 1950s, and that's on farm strips. So that's what's traditionally been done in this district, and I think it's important that we're able to retain our traditions and not have regulations and costs imposed upon us. So thank you for listening to us.
Thank you, Mr. Macaulay. Really interesting hearing your background and experience. I'm interested in, I guess, in terms, you mentioned the effort and time and activities required to keep your flying current.
Yes.
How do you become a pilot in the first place? In the sense of, it would also be important, what I'm hearing is that for someone to train and learn and to keep the succession of qualified pilots going, to be able to continue these activities, what does that take?
Well, we have the South Canterbury Aero Club, which has traditionally always had instructors, very difficult to maintain commercially. It's an absolute struggle to keep them viable. It has been since the day they started on the Saltwater Creek airstrip, was where it started, and the instructors will start with a student on the airport, and then once they've got the student up to a reasonable level of competency, they then need to expand out to cross-country flying, and that involves landing on off-airfield strips and practicing forced landings is an essential part of learning to fly and being current, and this area has a great advantage in that it is what is termed as an uncontrolled airspace. So it's something unique for South Canterbury. It's probably one of the few areas in the country that's got a massive area of uncontrolled airspace between the Christchurch, Dunedin, Queenstown airports. So I think this council would be doing its citizens a great disservice if it starts imposing regulations on flying of private aircraft.
Thank you.
I just wanted to add to that. So, and I think what Mr Sinclair and yourself, Mr Evans, has highlighted that when these the Aero Club instructors are training new pilots, that they may utilise your airstrips to help support this training, which is obviously, you know, critically important to bring the next generation through. So, yeah, I think it's been really good to understand, you know, the non-commercial aspects to this. So, thank you very much.
Thank you, Mr Moore.
Thank you, Mr Macaulay. The next witness is Mr Caldicott.
Good morning, Commissioners. Thanks for the opportunity to present my submission, which I understand you've all got copies of. I'd like to summarise, if I may, with some brief points. It's the first time I've ever done this in this forum, and it signals in itself my passion for light aviation. It's my single largest recreational endeavour. The essential points that relate to my submission in paragraph 3, aviation has been and continues to be a huge part of my recreational activities. Our farm was bought due to its suitability for aircraft operations. And I'm sure my wife will remember when we stood on our proposed house site, I was more interested in the paddock down the front and its orientation to the wind. Our farm's been continually used for my recreational flying for over 30 years. Our plane lives in the hangar on the farm, and that was the first building that went onto our farm when we purchased it. My aviation has positively contributed to the experiences of my neighbours, not only joyrides and aerial photography. Often look for escaped deer in the riverbed. We've spent several days searching for a family member lost at sea, and even done some work for police searching for vehicles at times, all based from my farm. We'd go to Timaru Airport to refuel. Often I have fuel at the farm and I'm able to take off and land there. I do hold my neighbours' rights to peacefully enjoy their properties in very high regard, as they do my rights. We have had, ever since we've been there, a very good relationship with my neighbours, not only in aviation but in all things rural. My flying activities occupy a very small amount of time. I simply leave by air and after a couple of minutes warm up, take off and depart, and sometime later in the day or some days later return to the farm, similarly as one would in a vehicle. The take-off phase produces the most noise, but it's only for a few minutes. Landings go almost unnoticed. Often there'll be no flying activity from my place for more than a week or 3. Wind, rain, winter conditions, a whole host of things come into the fact that it's not a daily occurrence, but on average, it may be an hour a week, as my submission talked about. The proposed setbacks will prevent me from enjoying the full extent of my rural property for my recreation. The proposals will prevent my flying activity based on potential noise or amenity issues where none have been identified. The proposals seem to be due to the nature of the activity rather than any adverse effects from it. With regard to noise, caused by my aviation activities. All rural areas do have activities that produce some noise from time to time. Our house is less than 30 metres from the adjoining farm boundary. There are fert trucks, there's chainsaws, motorbikes, harvesters, hay, silage, you name it. The trucks go past, we say, oh, yep, and carry on with our life. We're not picking up the phone and ringing the district council because there's some, noise. It's only momentarily often, but it can occur for longer periods and often at all times of the day and night, depending on the activity. There are some practical steps that pilots can take to reduce aviation noise. Reduced powered takeoffs are possible at times, although not entirely part of the safety plan. But the more important thing is a carefully planned approach and departure track, so you're not flying over neighbouring houses, the horses, sensitive livestock, buildings. So it just involves some common sense approach to how you work in the environment. Aircraft are permitted by civil aviation rules to operate down to 500 feet or about 160 metres above the ground level. So once I get to 160 metres or 500 feet above the ground, I then come into civil aviation jurisdiction, if you like. And so I could fly around all day at 500 feet if I chose to. And perhaps that would cause a nuisance, but the Timaru District Council is trying to control a very small box up to 500 feet. Above that, I'm not sure the district plan would extend to noise at that altitude. Civil aviation rules also restrict non-night rated pilots from operating outside the daylight hours. So flying in my type of light aviation is very much a daylight hour activity. In summary, with respect, I think the proposed rule should be abandoned in its entirety. I think a common sense approach should continue to prevail and that light fixed wing aviation from rural airstrips within the district should continue to be a permitted activity as in the past. Thank you.
That?
Thank you, Mr Caldecott. No questions as such, but your presentation's been very clear and very helpful, as your colleagues.
Thank you very much.
Thank you.
Thank you, Mr Moore.
That concludes the list of witnesses that were part of the joint presentation this morning, but I note that Mr Brodie is here with a submission on the same topic. Perhaps we might hear from Mr Brodie in terms of his submission, and then I might just wrap up on this topic if that would be convenient.
Yes, I'm happy that. I was just going to clarify where Mr Brodie fit into the issue. I've also got some points I would write to or matters of clarification for Mr McLennan and Ms Vila as well in relation to the topic. So happy to proceed on that basis.
Okay, well, we'll hear from Mr Brodie now. So.
Good morning, Commissioners. And as Mr Caldecott mentioned, this is my first time, so excuse me that to work through. Russell Brodie is my name. Based at Rangitata Island, family's been involved in aviation since 1917 when my grandfather was the first trained military pilot from South Canterbury to train at Sockburn or Wigram as we know it, and served in the Royal Flying Corps. I'm a member of a number of different organisations, including Aircraft Owners and Pilots Association, which Mr Evans represents. I'm also an executive member of the Recreational Aircraft Association New Zealand and a flight testing officer and an inspection authority, which means that I'm there to check pilots and aeroplanes. I can get into a little more of that later. I know the questions have been raised. But the Recreational Aircraft Association represents about a third of the recreational aircraft on the New Zealand register. So between the different organisations, the Aircraft Owners and Pilots Association and the Sport Aircraft Association, there's probably, as Mr Evans said, at least 90% of the recreational aircraft in New Zealand that we represent. And also the question, just a few notes I'd made as it came up to help, that I just did a quick tally that my estimate is somewhere between 70 and 80 privately owned recreational aircraft in South Canterbury, which is also a very good thing, even when I had to stop and think, because you very seldom hear it, and if it's an aircraft, it may not be somebody local, it could be an aircraft that's travelling through. I've been the operator of Rakatara Island Airfield for the last, 40 odd years. I've been a flight instructor for most of that time, so that's teaching people to fly. And having airstrips around has been raised as well, and I'm sorry to cover it again, but it's a very critical part. It's like learning to drive and you're told, well, you can use the car park or you can use the motorway, but you're not allowed to practice driving on the streets. You know, having little airstrips around our airfield at times has been used. We've assisted the police. The police have used it. We've been called out search and rescue, people lost at sea, people lost on land. We've had other aircraft available, as Mr Caldecott said, that have been based on other airfields around. On one occasion the weather wasn't suitable, but we're able to talk to other aircraft on private strips who were able to come along and assist, which we were happy to do as part of, I guess we look at it, at what we do as being there as part of the community to be able to do that sort of thing. But the flight training is very controlled. As Mr McCauley said, that every flight is either authorised by an instructor or it's by a pilot who's certificated or licensed, and that relicensing and biannual flight review happens every 2 years. It doesn't matter the kind of aircraft, be it the smallest microlight through to a more advanced aircraft. They have to be looked at by an aircraft engineer and signed off every year. So you're looking at a group of people, we're operating within the CAA rules, that it has to be done that way, and there's no ifs or buts. There's no rat bags, you just go do it. So it's a pretty controlled sort of a thing. I think that's, covers a lot of the points have been covered previously, but it's, I just wanted to say, with a history of aviation, it's been a very proud one in South Canterbury. I founded the South Canterbury Aviation Heritage Centre 20-something years ago. The airfield at Rakatara Island, we host an Anzac service which is growing, and some of you may have been there. I know the Mayor has been on a couple of occasions, and we're always delighted to host that for people in the community. We have different events happen that involve community. We've had a number of fundraising events that have happened, and people who have come to those events mostly have come from private airstrips. And it comes back to my original submission to it was basically, why is there need for a change? Nobody has been able to, Mr Evans couldn't get an answer of what the count, whether there was a problem. And I'm a belief, if there isn't a problem, why solve something that doesn't exist or nobody has made it exist? I believe that pilots are a very responsible lot, and we're not doing dumb stuff like flying below 500 feet, because the rules, you're going to get your ear chewed and severely if you do that kind of thing. So, yeah, that pretty much sums up what I'd like to say, but just finish, where would we be with one of our most famous citizens, Richard Pearce, if he hadn't had a little airstrip to operate from? Thank you.
Thank you. I just wanted to revert back to Mr Evans, if I may, just in regards to what consultation did the council carry out with the different organisations that you're involved with regards to drafting this rule?
The same as every other council we've had any involvement with, which was zero. We submit on a lot of district councils. Most recently was Plan Change 23 with the Mackenzie District Council. That was an interesting one because we actually got leaked. Well, they asked for this consultation, and we actually got leaked a draft of what was being proposed in the rule. So they had the rule already written. They got leaked out somehow, and then they said, we'll run the consultation. And about the 6 pages of consultation inviting submissions from the community, there was one light item that said how aircraft, commercial and whatever is managed in our region. That was the only thing that prompted us to spool up a response, only because we'd had the leaked rule, which was even more radical than the Timaru proposed, and because I don't have the time to go to every single hearing, that's actually gone in, and it has the 1 kilometre setback, the 514 hectare exclusion zone. If we can find the money, we'll be appealing it with the Environment Court, but I don't think that's likely. So anyway, following that, we probably put in about 50 or 60 submissions from people throughout the community into the Mackenzie District process. And as is quite typical, the planners and reporting officers take very little notice of what is submitted through the public, through these consultations. They carry on with their agenda to put in these plans, as has been the case for Timaru, not based on need. And before you know it, they're entrenched, and unless we can fund a type of response like we have here, which is totally unsustainable if we roll this out amongst 67 other territorial authorities, they end up entrenched and we're just powerless, and like everything else, we're just going to go, well, stuff the rules. We can no longer comply with everything, and we're kind of strangled.
Thank you for that, and thank you, Mr. Brodie, for your submission.
Well, that does conclude the evidence in relation to the opposition to Rule GRUZ 14 in relation to non-commercial small fixed-wing aircraft. The evidence that's come forward this morning in my submission continues to highlight the underlying premise from these submitters that there's not a problem to be worked on here for this plan. And so my concluding submission is that the relief that is put forward as attached to my legal submissions is indeed the most appropriate planning response to the evidence that has been filed in this matter, and I look forward to seeing where the plan lands in terms of your recommendations.
Thank you, Mr. Moore. Ms. Beeler, some questions for you, or some homework for you. Just following up on this issue about the Lagoima request and the lack of response, the panel would like to know whether or not there is any record of any complaints in relation to non-commercial fixed-wing aircraft. We would also like to know what monitoring the council has undertaken in terms of the efficacy of the operative district plan and the rules that applied under the operative plan. Also, what is the evidential basis that led to the development of the rule in the first place? It's not apparent to us from the Section 32 report what information the council has acted on. So I think that probably falls upon you as representing the council in this process to make those inquiries. Mr. McLennan, for your part in terms of your 42A function and the evaluation of submissions and also your recommended alternative provision, there are some gaps. I'm not clear, based on your report, you refer to the need to balance the objectives in the proposed plan relating to prioritising primary production and protecting sensitive land uses. What does the Canterbury Regional Policy Statement tell us about the appropriate balance? Is in fact there a balance to be had? At least as we've discussed over the last few days, it appears there's a prioritisation of primary production and the activities that support that production. So we're left unclear as to where the balance argument lies. Also, could you look at, in terms of your proposed alternative rule, there's been an issue raised around scope. So are there any submissions that would give you scope to pursue that rule in these proceedings? And also, given that that wasn't the proposal when the provision was notified, we think it is incumbent on you to provide us with a Section 32AA evaluation for that rule, if in fact there is scope for it to be pursued. That I know that you will have an opportunity to reply to the matters, but there is some urgency in relation to those aspects. I think that that's something that we need to receive from you sooner rather than later. So,
Thank you, Madam Chair. We're happy to do that. I just note as well that, of course, the noise-specific rules are sort of flagged for a hearing later and a different 42A officer. But, I mean, I think we can sort of deal with this the best we can now, but that's probably part of the reason why Mr McLennan hadn't gone into great detail around the specific sort of noise rule, because the way that the hearings have been sort of divided up, or the topics have been divided up, noise is something that's being dealt with a little bit further down the track. But we will work with that 42A officer at the same time, just to ensure that there's sort of no inconsistency issues along the way as well. So
I don't think we want to wait until the next hearing to understand why the justification for the noise rule alternative.
no, I'm not
I
suggesting.
mean, there's some critical information. I mean, does the council know, for example, how many airstrips there are that would be affected? Does the council know the percentage, for example, of flights that are related to supporting primary production versus recreation versus other non-commercial activities? I mean, there's quite a lot of information that we simply don't have in front of us.
I understand.
Just, if I may, through you, Madam Chair, a couple of follow-ups in relation to the discussion you've just had with the reporting officers. In relation to your question about the evidential foundation, I'd simply flag that I may seek leave to respond to any fresh evidence that is adduced at this point in time. At the moment, there's no evidence on the record, and we're late in the piece for fresh evidence in relation to this.
I'm not suggesting that the council go off and commission any additional evidence. I simply want to know what is on the record that supported the rule. Thank you.
Thank you. That clarifies that point. The second point, in relation to the potential introduction of the noise provisions being of relevance here, there may be an issue in that the submitter may need to participate in the noise chapter, and so it will be extremely helpful to understand where the council lands well before that chapter is to be considered. On the face of the plan, as it was drafted, there wasn't a need to engage on that topic, so an answer sooner rather than later would certainly assist.
Thank you. And perhaps, Ms Vela, if you could just reflect on the list of matters that we've sought and give us a bit of a time frame, perhaps tomorrow, as to when you think that could be available for the panel. Thank you.
Thank you.
Thank you for your attendance, and we'll take our morning break. Tēnā koutou katoa. Sorry, Mr Williams. We have a submission this morning from Fonterra Limited. Mr Williams.
Good morning. You can hear me okay? I almost had to begin with an apology for the amount of evidence we've produced as a part of this hearing. What we've really tried to do is set out the Fonterra case generally for the wider hearing process. So certainly there are some matters that are relevant for hearing B, but equally this really provides context for the entire Fonterra case. So we're not proposing to duplicate this in future hearings, which you'll be pleased about. So I've also got two witnesses online, hopefully, and I'm not sure whether they're being dialed in, but we'll cross that. They have been. Dave's there. Oh, and Mike's there. Sorry, I'm looking at the wrong screen. So I'll try and, so that's Mike Copeland and Dave Smith, which is good. So I'll try and insert them earlier so they're not waiting online forever. But with pre-exchange legal submissions, I'm conscious of that, and also I'm going to produce a small set of supplementary legal submissions as part of this hearing to talk to the NPS HPL point in particular. I sort of covered the Fonterra story to a certain extent as a part of hearing A, but just to briefly recap, the existing site's currently zoned industrial H and rural zone, and is proposed to be rezoned general industrial and general rural, and subject to a number of overlays in the proposed plan. The primary concern of Fonterra is just really whether the general industrial zone in particular is really fit for purpose for the site. We're not saying in any context that a general industrial zone is impossible, but certainly what we are saying it is impracticable, and sort of produce evidence and legal submissions around that. As the panel will be across, we originally, or Fonterra originally submitted seeking a special purpose zone strategic rural industry, and that was really in the context of the time of having had discussions with particularly Silverfern Farms and Ravensdown, but that's obviously been refined through the hearing process to a dairy manufacturing specific zone, being the Clandeboy dairy manufacturing zone. I've covered in legal submissions the issue of scope. I'm not proposing to cover that in any detail unless the panel wants me to. Really the key point here is what is now proposed is a material reduction on what was set out in the original submissions. I don't think there's any scope issues at all that arise from that. I've just set out in paragraphs 13 to 23 a bit of detail on scope more generally, but I think again it comes down to, as is the case with any scope issue, whether there is an issue of procedural fairness or submitters not being aware, and that's obviously not an issue here. Clearly what is now proposed is a reduction and a refinement of what was in the original submission, and we're not trying to tag things on. So, in paragraphs 24 to 34, I've set out a discussion on reverse sensitivity, and this was in part, if I'm honest, a response to a heads up I had from Commissioner Robinson during the hearing A process that was a live issue for the hearing panel. In the case of Fonterra, reverse sensitivity is obviously a relevant matter. In the submissions, I've referred to objectives 521 and objective 532 of the Canterbury Regional Policy Statement of sort of providing some context. To state the obvious, they, from memory, actually apply to regionally significant infrastructure. So in the case of Fonterra, it's more driving at primary production, and in the context of the RPS, that's the likes of policy 5.3.12 and the air discharge one, which I did have a note of, which is 14.3.5. So those policies from the RPS are pretty directive in my view in terms of, to quote, avoiding development and or fragmentation, which results in reverse sensitivity effects that limits or limits primary production per se. So we've certainly provided, or Fonterra has provided some evidence and submissions around the objective and policy being sort of, or being proposed as a part of the district plan review process. And I think the officers have largely, not that that view is binding on the panel, accepted the Fonterra proposed relief, subject obviously to the issue of whether there is a special purpose zone for the Claneyboy site being expressly provided for, or whether it's just covered by the general industrial zones. So, also covered off the national planning standards, and I'm conscious I also covered this off in hearing A, so not proposing to spend any real time on this. I think what the hearing panel now has in front of it is the evidence, particularly of Ms O'Rourke, who's sitting along from me, with regard to what the current industrial zoning practically has meant for Fonterra, which is in a seemingly permanent process of applying for resource consent. That's really painful for an operation such as Fonterra, where we're having to reconsider quite, to be blunt, irrelevant matters such as landscaping and things like that, which might be entirely suitable in a more orthodox urban industrial zone, but certainly don't really raise any issue here. We did, just to sort of cover off the options on that, we did very carefully look at the option of a precinct in terms of preparing for this plan review process, and in particular this hearing. Where we sort of reached on that was, I think a precinct can work quite well, and like an example that's currently in the plan is the Washdyke Industrial Expansion Precinct, where you're effectively just tagging on, in that case, one thing being landscape. It gets really cumbersome when you're dealing with a Fonterra-esque type operations, where you have to effectively end up writing an exemption within every standard or every rule to cover the Fonterra operation. So we're not saying in any context that a precinct is impossible. It just becomes really inefficient in terms of applying and administering the plan, and equally, you know, I think it is appropriate to take a step back and go, what is the general industrial zone really geared for? And in my submission, it's not a site such as this one. So, and then the NPS HPL, I've actually handed out another, which I don't know if it made it right away along the bench, but short set of submissions. Much of this has been covered in evidence, but I thought it would just be good to crystallise some of the points in terms of, and this is particularly driving at the rezoning of what on the scale of the Claneyboy site is a very small area, which is the land at 37 Rolleston Drive and 2 Kotuku Place. And as you would have seen from evidence, Fonterra sees that land as being appropriate or essential for development, particularly in relation to its biomass project. So what I've tried to do in these supplementary legal submissions is just talk a bit more detail around that project and the pathways within the NPS HPL. Now, Ms Tate will pick up the more purist planning objectives and policy type context, but really the purpose of these submissions is just to set out again what I have covered in part in the primary evidence. But so just really, and I'm not going to read these in detail because I appreciate the panel will go away and read these in detail, but just
I think it would be helpful if you just focused on the stepping us through the NPS HPL.
Yep.
Don't worry about the evidential matters, that will
Yep.
come out, and if we've got questions.
Yep. So maybe if I start at just my paragraph 7. So as the panel will be well aware, clause 3.64 provides a pathway for the rezoning of the rural land. I've stepped through 3.6.4 in the legal submissions, as I've done previously, but I'll step through it again here, which is really driving at the Commissioner's point. Really conscious that there are some aspects of the submission that require further clarification, and certainly some aspects are set out in evidence, but in preparing this I've also checked in with Fonterra on some of the outstanding evidential points as I see it to try and confirm those. So So we consider that the information set out below, in addition to the information providing the legal submissions, demonstrates that the rezoning, and this is picking up on obviously 3.64, the rezoning is required to provide sufficient development capacity to meet demand for business land in the district. There are no other reasonably practical and feasible options for providing the required development capacity. In particular, land is needed for the biomass project and is the only reasonably practical and feasible location for this project, and the benefits of rezoning outweigh the costs associated with the loss of highly productive land. So paragraphs 9 to 11, I've just expanded out on where the biomass project is at. Mr Burdett, as I note in my paragraph 9, has covered this in evidence to an extent. And really the key point being here, or the point I'm aware of being, is not right at this moment in time a matter of formally committed capital. But having said that, what I've set out here is it's part of a wider formal commitment by Fonterra. So we're not at just pick up in my paragraph 9, we don't currently have formal plans or designs that can be provided to the panel, but we emphasise that the project has been in the works for quite some time and is part of Fonterra's wider decarbonisation strategy. So just to be clear, this hasn't been prompted at all by the review process. This is a bit of work that has been going on. So as a part of the decarbonisation strategy, Fonterra is targeting a 50% absolute reduction in Scope 1 and 2 emissions by 2030 from a 2018 baseline, with a forecast capital spend of around $790 million, and that includes a government contribution of $90 million through the Government Investment in Decarbonising Industry Fund. So just to provide some context for that, that is focused on the burning of coal. Now, the majority of Fonterra's North Island sites are able to access reticulated gas, so do not burn coal at present. So this has a heavy South Island focus in terms of the decarbonisation strategy. And Fonterra publicly announced that it was looking at the biomass for the Clandeboye site and its Edendale sites in July 2023. And I've provided in footnotes there's some actually quite good media releases and publications for Fonterra around that. The biomass project for the Clandeboye site is just one of several projects already underway to decarbonise the Fonterra business, as I noticed, the coal being particular focus. So Hatapu, Te Awamutu, Waitoa, Brightwater and Stirling sites have already installed biomass boilers. And all the remaining South Island processing sites, as I noted, which are all reliant on coal, have been identified as a part of the project. So there is a formal project and decarbonisation strategy underway, which has formally identified all South Island sites, with the Clandeboye site and the Edendale sites, if you like, being the ones that have been specifically identified for biomass projects. So paragraph 13, I've just emphasised that, which is probably a trite proposition, but proposing and designing and implementing a project such as a biomass plant of this scale requires an enormous amount of time, investment and strategic planning from Fonterra. The planning for the biomass project has been and will continue to be completed independently of Fonterra's involvement in the plan review process. It is likely that there will be a formal public commitment to the biomass project at the Clandeboye site by the end of 2024. So I'm not sure of the panel's wider timing, but it might well be that by the end of this hearing process there is an update we can provide, or at the very least we can give an update in terms of progress continuing to be made. So put simply, for the purposes of the plan review, and although it cannot be expressed in absolute terms, there is a high level of confidence that the biomass project will proceed. So sending my submission in accordance with clause 3.64A of the NPS HPL, you know what that means, but that the land is necessary. The current situation is in some respects different than that which might typically occur in relation to housing or business land in a district. And what I'm picking up on here and just turning over the page is this is not a case of a council looking to its forecast business land growth and assessing what areas might be required to accommodate that. The reality is the biomass project needs to be adjacent to the existing site. It cannot be located elsewhere in the district, or equally, which is sort of the perverse scenario. The entire site cannot practically be moved to another business-owned area in the district. Rezoning, especially in the context of a special purpose zone sought, would avoid Fonterra seeking additional consents in the context of an existing rural zone, which are unnecessary and inefficient, and I guess uncertain were it to retain its rural status. So,
Mr Williams, so just, we need to be clear, don't we, that if the barrier to the rezoning is the MPS HPL, is it your submission that the circumstances which Fonterra find itself meets the requirement of 4A? Or are you asking us to kind of create an exception to 3.64A?
Oh no, I think it meets 4A. I'm not trying to create a grey area for the panel to step into for the sake of supporting Fonterra. In my submission, it does clearly meet, it is development capacity that is required at the site. As I said, the tie here, and I'm not wanting to conflate the 2 points, is the business land in this instance has to be located adjacent to the existing Fonterra site. So there is a geographic element to the application of 3.64A.
But you're asking us to find on the evidence that the urban zoning, whatever that is required to provide sufficient development capacity to meet expected demand for business land in the district.
Yep.
And you're saying that we can tick that box based on the evidence?
Yep.
Okay.
And that's...
It was a rather long way around that topic.
Yeah.
I interpret
And I'll
you to
talk-
suggest that it was different to what might be contemplated by that
What, as I said, so really I was covering 2 points. One is that I'm not sure this is an issue at all, but I just wanted to square it off entirely. The first point I covered was just actually how serious is Fonterra about this, i.e. is the rezoning required? What I've sort of hopefully set out in a bit of detail now, as supported by evidence previously, is that it definitely is required, other than a absolutely final formal capital commitment. This project has been in the planning stage for a long time, and at a national level there has been budget put aside for it. The other comment on why is the rezoning required is, in terms of 3.6A, is just making it clear that land, the demand aspect or the requirement for the land is not addressed by rezoning other business land in the district, which is probably really overlapping or coming down to 3.64B, which is no reasonably practical or feasible location for development. So really my paragraph 16 is probably more a segue into that, which is a trite proposition in both cases. The Fonterra can't use business land elsewhere in the district for the biomass plant, and equally the entire Fonterra Clandeboye site can't be relocated elsewhere in the district for the sake of getting a slightly larger site, which might better accommodate what's proposed here. The benefits of rezoning outweigh the costs associated with the development. I think this has already been comprehensively dealt with in evidence. It's a huge, I think this panel's done a site visit, so just in terms of its physical presence, it's a huge site, but in terms of economic investment, we're looking at about $1 billion piece of kit, a serious piece of infrastructure. The biomass project, and Ms Tate talks about it, is a really important part of Fonterra's wider national commitment to decarbonisation and rezoning what's a relatively small area of land in the context of the Clandeboye site, and for that matter the district, will enable Fonterra to give effect to that. Paragraphs 23 to 25, I've just set out the sort of alternative pathway. As I said, I'm pretty comfortable with 364, but 311, continuation of existing activities. Again, the panel will be well familiar with this, but Territorial authorities, as a directive clause, must include objectives, policy and rules in the district plans to enable the maintenance, operation or upgrading of any existing activities on highly productive land. So in effect, that includes the planning board site. 24, clause 3.11 does not appear to be strictly limited to only that land previously consented or zoned for the relevant activity. It does also appear to be engaged where an existing activity is reliant on, in this case, adjoining land for the purposes of continued operations. And just at paragraph 25, I've just put a note in re the Clandy Boys school site. That's, in my submission, that's a pretty peripheral point, effectively removed from rural uses already by virtue of existing operation. So that was the only point I wanted to make around that. So I've tried not to repeat what I've put in my submissions previously or repeat what's put in evidence, but I've just tried to bring some of the NPS HPL material together in there. So that is all I was proposing to cover at this stage anyway. So.
Thank you. I don't think the panel has any questions. Oh, you do?
Sorry. Just on your paragraph 25, obviously Fonterra would have considered the school site for the biomass burner. Did they consider that site at all?
Yeah, I don't think the school site's big enough to accommodate the biomass burner per se,
Right.
so it does need
A bit more land area.
must take and point to the relevant plan and evidence that you point and just explain the relevant proximity of two parts. So. Yeah. Yeah. And both of those are in general rural, so it's sort of a bit of a moot point. So.
Right.
Yeah.
Okay. Thank you.
Right, thank you. So in terms of evidence, and I appreciate the panel's read it already, I might, if they don't mind, just so they don't have to sit around all day, see if Mr. Copeland and Mr. Smith are around. Mike, are you there?
Yes, I am. Can you hear me?
Yep, no, that's good. And just for the panel's benefit, a couple of witnesses are going to do summaries, but I'm not proposing to have summaries from the witnesses. I'm assuming you've read their evidence already. I'm assuming also that the panel knows Mr. Copeland well, so just really a matter of questions and answers, but in the panel's hands, of course. So.
Thank you, Mr. Copeland, and thank you for your evidence. My name's Cindy Robinson, and I'm the chair of the hearings panel. Look, just reading through your evidence, I don't have any questions in terms of the economic value and significance or importance of the Clandy site to the regional or beyond economy, but you make comment in your evidence about the need to protect that investment and addressing issues such as reverse sensitivity. And I just wondered, had you been to the site at all at any point?
No, I haven't.
Okay. Are you aware that basically the site is surrounded by rural farmland and that, well, from our observation, I don't know if you're in a position to confirm it, that there are not a significant number of dwellings or other sensitive activities except perhaps a preschool, which I think is located nearby?
I'll accept that.
Yeah. So in terms of, is your concern from an economic perspective more about providing or enabling the activity within an appropriate zone as the first priority, or are you concerned about the impact of other activities encroaching on the boundary of that zone that might restrict the operation of the Fonterra plant?
I'll leave it to the planners and to discuss that, other than to say that I think my evidence was just highlighting that the current site and the current surrounds is ideal for the purposes which Fonterra wishes to use it. And that's why I'm suggesting that whatever protections can be given for those activities to continue and to the extent expansion is required, to be unhindered, if you like. I think I was only making the comment really sensitivity in a general sense that it would be undesirable if productive capacity from this plant had to be located elsewhere where such issues may arise.
Thank you. That's helpful clarification for me. I'll see if other panel members have questions. Commissioner Solomon?
No questions from me, thank you.
Well, that's short and sweet. No further questions. Thank you very much for your evidence.
No problem.
Thanks, Mike. Now, probably roll with, I've got two Mr. Smiths, so Dave Smith, who should be online as well. So, yep.
Yes, good morning, everyone. Would you like me to talk to my evidence or just go straight to questions? I'm in your hands.
Could you just give us just a quick summary? I mean, that we've had a huge volume of material that we're coming to grips with, so just give us a quick overview of your evidence, and then I'll see if there's any questions. Thank you.
Yep, certainly. So the scope of my evidence is actually quite narrow. It focuses on one particular transport rule in the proposed district plan, which is in the transport chapter S20. Now, the significance of this rule is that we refer to it as the high traffic generator rule, and it provides the thresholds for which a transportation professional would prepare an integrated transport assessment. And those thresholds for industrial activities are generally they are a function of the actual size of a application in terms of gross floor area that would be added to a particular site. So my evidence is that this is generally appropriate for industrial activities where you'd have about one vehicle movement for every 100 square metres of additional gross floor area which is added, and that's backed up by a whole lot of literature which we as transportation professionals commonly look into. But in the context of the Clandeboye factory, the actual traffic generation rate is a lot lower, and we know that because the factory's collected a lot of good information around vehicle movements, which remains applicable, and we know what the floor area of the site is. So rather than 1 to 2 trips per 100 square metres, the factory is more in the vicinity of 0.4 trips per 100 square metres. So when I've been reflecting on that transport rule, the S20, I consider that it's more appropriate for any future development applications in relation to the Clandeboye factory to go with the, to refer to the mixed use or other activity row within that S20 table. And that directly looks at how many vehicle movements are going to be generated by a particular application. And in doing so, it provides a more equitable basis for deciding whether an ITA, or an Integrated Transport Assessment report, is actually required for the site. So I made a recommendation to Ms. Tate that that mixed use or other activities row would be appropriate. And I see that has been included in her evidence as well, as an extra note or an amendment to that high traffic generating activities rule, and that's on page 30 of Ms. Tate's evidence. Yeah, I think that sums up my evidence quite nicely. Are there any questions around that?
Thank you. Commissioner? No, there are no questions for you. That's all very clear and helpfully set out. Thank you.
You're most welcome. Thank you very much.
Thanks, Dave. I'll now follow the order that's in paragraph 73 of my legal submission, so that'll mean a little bit of musical chairs. So we'll have Mr. Burdett up. No, Ms. O'Rourke, sorry. I'm not reading my own submissions. You've heard from Ms O'Rourke previously in
Yes.
terms of hearing A, but I think she has got a very brief couple of points or summary she may talk to. So,
Thank you.
Thank you. Morning. Yes, so we were obviously here a couple of months ago to talk to the strategic directions in the as part of this process. So I guess just a very short summary of what my evidence addressed. So firstly, we talked about the current policy framework, and I talked to the challenges that has created for the site. There is an extensive consenting framework that governs activities at the site, and that includes consents held with both the District Council, around 18 consents, and another 35 with Environment Canterbury. So 53 consents which govern activities at the Clandeboye site. And that consenting load has been considerable in the last 7 to 8 years, with at least 10 consents granted. And obviously each time those consent processes happen, there is the work associated with that, and very much in terms of the business, I guess a delay while the consent process takes place before the business can have certainty that that activity will happen. And then there's an extensive business process that goes along with that. So a considerable piece of work. We have a team of 4 at Fonterra who manage all the resource consents across the country, and they start those processes 5 years before a consent is due to expire. So an extensive process for the team at Fonterra. And then also, obviously, once those consents are granted, there's an extensive compliance monitoring and enforcement process that follows, a process that's managed both by Fonterra as the consent holder, and then by the council with their staff who also have that work to manage. There's quite an extensive process that goes once a consent is granted in terms of the consents team then work through those consents with the environmental managers at the site. So in this case, the Clandeboye environmental manager would be briefed on those consent conditions, considerable work in understanding their responsibilities with those consents, and then they ultimately hold that responsibility to achieve compliance with those consents. And so then moving on to why Fonterra has requested a proposed special purpose zone. My evidence talked about some of the challenges with the current zone. I talked to the particular provisions that related to landscaping, temporary buildings and noise, and some of the challenges that therefore created an ongoing realm of consents. So in seeking the special purpose zone, obviously as we've talked about, the purpose of this is to recognise the significance of the Clandeboye site, as has been covered in the economics evidence, and we're looking for a policy framework that is more efficient and provides greater certainty to Fonterra. We've looked at what is currently on the site, we've looked at the existing buildings, the existing traffic, existing noise levels, and then started to build a tool which would be the outline development plan. So taking into account how the site operates at the moment, we've proposed an outline development plan which sets a baseline for which activity could take place at the site, and that sort of activity would be permitted, so not triggering the need for resource consent. And then that approach would provide greater certainty to Fonterra, along with the council and the community, about what level of effect could take place. While it's not possible to anticipate the future demand for dairy, and this is often a question asked in terms of what is the future, and while we don't know exactly what the future is, we obviously are aware of some future development scenarios that we're looking to address. And Ben has talked to this in his evidence, as have a number of other people in terms of Fonterra's decarbonisation program. It's extensive. The Clandeboye site discussions, I've been involved with those for a couple of years now. I was involved with them at the outset of this process. But while that exact project hasn't been confirmed within the council in terms of its location, we do know that that project will take place. So in summary, we're looking for a framework here which will enable the site to operate more effectively and efficiently, and we believe the special purpose zone is the appropriate mechanism to achieve that.
Thank you. Can I just ask from an operational perspective, if the panel wasn't persuaded that there should be a special purpose zone, but that some form of outline development plan or precinct was able to be accommodated within the current zone framework. Does that create a problem operationally for Fonterra?
Yeah, I guess it's difficult to quite understand what that might look like in effect. So an outline development plan with some level of, I guess, permitted activities would be definitely preferable for creating a greater level of certainty than there is at the moment.
But it's not really tied to what the zone is called. You're just looking for whatever the appropriate mechanism is to smooth the pathway for consenting and compliance and monitoring inefficiencies that you're currently experiencing.
Yeah. Again, without actually just thinking through all the implications for a different approach, I'm not sure I can kind of answer that entirely in full, but I guess we're happy to continue conversations to look at alternatives around how we can best achieve that certainty for the site. And obviously there's been a lot of work taken place around the outline development plan. As you know, we've seen this approach work well at Selwyn, so happy to consider what those other options might be with those intentions to reduce the consenting burden.
Yeah. And just in terms of managing that consenting burden, for the most part, are your consents, are they publicly notified? Do you require the written approval of neighbours? I'm just talking about Clandeboye here.
Sure.
Or are they generally non-notified consents with a degree of certainty around what information you're required to provide the council to satisfy those requirements?
Yeah, so I guess with that large number of consents that govern Clandeboye, we often tick a whole number of boxes. So straightforward consents at the site, which might be, ancillary buildings on site, obviously often non-notified, which is consistent with the approach, nationally. Obviously non-notified means that there's some certainty of the outcome, but there is obviously an extensive process that sits behind every resource. And then moving through to the other end of the spectrum, which is the more significant consents, such as the wastewater discharges, biomass, those sorts of operations where there may be the need for limited notification. Most of our discharge consents are publicly notified processes, so far more extensive in terms of what's involved with those. I appreciate those consents largely sit with ECAN, but we do cover all ranges of that spectrum.
But in terms of land use consents with the Timaru District Council, do you have a sense of what the consenting burden is in terms of notification of those consents?
Yeah. Well, thinking back, I guess the most recent one was 2017. That was the mozzarella plant. Traffic and noise. Noise has been a consideration for some developments at that site. So I guess it could be that we were looking at limited notified in some of those situations. It's hard entirely to sort of look ahead to how they might be considered. So as I say, they may not be publicly notified applications.
Okay. And just in terms of if the rule framework does become more enabling, presumably there's still an acceptance that there is an ongoing obligation for monitoring.
Yes.
For compliance purposes.
Absolutely, yes.
Okay, thank you. I'll see if the other panel members have questions.
Yes, I just have one. In your paragraph 33, you say that it's not possible to anticipate the future of the demand for dairy. Why isn't it possible?
I guess in a general sense, it's just not possible to know what the future looks like. That is not necessarily the case.
But possible enough because you're spending $790 million on a bioburner.
Yeah, that is not anything to do with the future change in the demand for dairy. That is responding to a change in environmental expectations. It means all sites need to be decarbonised. So that isn't about expansion at the site, it's about a change in operations. So at the moment, obviously in the past, Fonterra has had been in a space where there's been increased demand for milk, and at the moment that increase is not as great as it has been in the past. In terms of what that future looks like, I'm not sure what that future looks like, but Fonterra is obviously focused on, and Ross might be better placed to speak to this, around improving what types of products are produced at the site. So we're not anticipating that things would change in terms of there being less demand. But yeah, again, I just can't say what that future is going to look like here.
Okay, thank you.
Thank you. I'm interested in asking you a couple of questions about the evidence, your written evidence statement. So at paragraph 19, you've offered us some examples, some practical examples around the suitability of standards such as landscaping and temporary buildings. The example that you've given around landscaping, you've talked about the risk of contamination, and you've provided an example at the Whareroa manufacturing site in the Taranaki region. Is this something that has occurred? There's been no similar incident for the Clandeboye site. Is this is something you monitor regularly and is of kind of a live issue for you, or?
Well, yes, yeah, absolutely. In terms of being proactive and managing issues before they come to hand, as a food production site, obviously, you know, the quality of product at the site is of critical importance. So for us, managing things like landscaping and those risks before they happen is critical to us. And the incident at Whareroa was absolutely a situation where we would want to be proactive so that that wasn't an outcome that happened again.
Thank you. In relation to temporary buildings, can you provide some examples of the types of temporary buildings you might need for the activities on the Clandeboye site, and the how that has frustrated perhaps your operations?
Sure. So I think the DIN project, which was a very extensive project at Clandeboye site that went over many years, obviously those are projects that take some time. I think 2 to 3 years was that project. So when you have extensive projects and you're obviously managing traffic and noise and all those effects that go with that, to find the need to seek consent for something which is arguably a very minor part of that project, and so far as it becoming a non-compliant activity, so the most onerous activity status for something which is essentially a building on a site. I mean, there is just no option for Fonterra not to have to go through that consenting process. So that is a case where we have absolutely had to have additional consents which seem disproportionate to the level of effect they generate.
Yeah, what was the name of that case?
That consent, I can come back to you with that detail. It's one of the ones since 2017 that we've had to have. Sorry, and the DIN project, that's a current project?
Yes.
Yes. Sorry, yes.
I'll just check I think that's all the questions I had for you. Thank you, it's very, very helpful.
Thank you. Thank you.
Thank you. So now plan use for the speech here, but Mr. Tuti for slide manager.
Good morning, everybody. My name is Ross Burdett. I'm the Site Operations Manager at the Clandeboye site. Just give a summary of my evidence. The Clandeboye site is one of the largest, Fonterra's largest manufacturing sites, and Fonterra's key asset in the Timaru district. Fonterra also owns 630 hectares near the site, where treated wastewater is discharged to land via irrigation. The Clandeboye site is a significant employer in the Timaru district and wider Canterbury region, and a valuable contributor to the greater South Canterbury community, employing 1,219 individuals, with wages and salaries forecast to be approximately 118 million for financial year 2024. The Clandeboye site itself currently has 11 manufacturing plants and processes approximately 40% of Fonterra's South into milk-related products. At peak, this is just nearly 13.8 million litres per day, processing across the season 2.3 billion litres, valued at $1.8 billion. The site's fleet of 70 tankers collects milk from over 895 Fonterra supplier farms within the central South Island, and the tankers which deliver milk to other sites in addition to Clandeboye collected approximately 383 million kilograms of milk solids in the 23-24 season, valued at approximately $3 billion. If the Clandeboye site could not operate during peak processing season, the only alternative would be to transport milk by truck and ferry to Fonterra's lower North Island manufacturing sites to the extent capacity allowed. To move all of the milk currently processed at the Clandeboye site would logistically not be possible, as there are not sufficient truck numbers to do so. Fonterra would therefore be at risk of not being able to meet its statutory obligations to process all supplied raw milk. In terms of the fixed assets at the Clandeboye site, approximately $854 million, with the reinstatement value of the facilities being approximately $1 billion. In 2018, Fonterra invested $240 million into the expansion of Mozzarella 3 line, which doubled Fonterra's capacity to produce individual quick frozen mozzarella and made the site the largest producer of natural mozzarella cheese in the southern hemisphere. As already been discussed, Fonterra's commitment to meet its carbon emissions reduction target of 50% by 2030. We currently transitioned 7 of its manufacturing sites that still use coal to renewable energy. This includes the Clandeboye site, and we're currently proposing to convert boilers 1 and 2 to wood biomass boilers, and this conversion is currently expected to take place mid-2025. In terms of resource consents, Fonterra holds a total of 53 resource consents authorising activities at the Clandeboye site. Of these, 18 are issued by Environment Canterbury and 35 are issued by the Timaru District Council. The consents issued by Environment Canterbury provide for activities including the take, use and discharge of water, and also discharges to the air, the coastal marine land and land, whereas the consents issued by the Timaru District Council relate to the development and use of land. The Clandeboye site has a positive history of compliance with its resource consent requirements across both local authorities. The site has not received any formal complaints in recent years in relation to its authorised activities. The site holds annual community meetings, which provide an opportunity for members of the community to raise concerns they may have with the site's operations. As the most recent community meeting in May 2024, no concerns were raised by attendees. In conclusion, given the nature and scale of activities that occur at Fonterra's Clandeboye site and the essential nature of the site for the surrounding primary production, it is important that any maintenance, repairs and minor upgrades to the site are not unnecessarily restricted by planning provisions. Fonterra considers that the most efficient and effective way of achieving this is via its proposed special purpose zone, Clandeboye Dairy Manufacturing Zone. Thank you.
Thank you, Mr. Burdett. I have a similar question of you, just in terms of the preference for the special zone. From an operational perspective, whether you have a view as to whether simply providing expressly for the same sorts of activities that you're seeking in the zone within the framework of the current industrial zone would be sufficient from an operational perspective.
I think that, as Ms O'Rourke said, it'd be very difficult to comment. I think without knowing further detail, for us, it's about meeting our major consents and being able to operate effectively and efficiently through minor works such as maintenance, repairs, etc., whereby additional request or need for additional consent would be a burden.
In terms of the consents that you've set out for the land use consents from Timaru District Council, just looking through the list, there's a range of things. Some of them are more significant activities where there's been expansions or of the site or activities on the site. But others are sort of more issues that might arise from time to time around installation of tanks, sort of operational changes. What's the problem? What is the most significant problem for you? Is it just these things that arise from time to time of a smaller sort of nature, or is it anticipating problems with potential expansion of the site?
Yeah, for us, it's the smaller activity. That generally with the smaller activity, we like to move faster. The bigger activity, the big expansion projects are properly planned, scoped, resourced and have a longer timeline, whereas the smaller activity tends to happen more often and in a fairly short time frame.
So within the current frame, the operative framework, not really nimble enough to meet your
Not really, no,
operational
not really.
requirements?
Yeah.
Yeah. Okay, thank you, that's clear from me.
Thank you, Ross, and I'll just let you know that your team did not let us figure out what the mozzarella plant was all about. As much as we tried to delve into the secretiveness of it,
Yes.
they were no. So you'll be pleased
Best
to know.
kept secrets, eh?
Very much, yeah. We prodded, but no, nothing there. So just letting you know.
Cool.
I suppose just following on from the chair, I suppose it's just you've demonstrated, or you've sort of talked about those smaller consents, establishing a silo and the inconvenience, I suppose, of those smaller things, and just trying to demonstrate that why it's impractical to continue sort of under that general industrial provisions. And I suppose that's what we really need to tease out here is it the burden of consenting, and having a special purpose zone would unhinge that, or, so I think for me, I just need to continue to read again through all the evidence to make to really understand what, just that it's quite a significant, zone change.
Yes. Essentially, with the smaller projects like installing a tank, any extending of a timeline can significantly impact production. So it's not necessarily the having to do the consenting process, it's the time it takes to do that for a smaller activity, where if we need to install a tank and to keep production running, it can have significant consequences if that timeline's delayed.
So just building on that then, with your other Fonterra sites, do you have similar constraints to consenting timeframes, or do you think that Timaru District Council may be a bit slower than others?
Oh, I don't think I can answer that. I'm not aware of the state of things at other sites, unfortunately.
Probably yes, that question wouldn't be for you, since being site operator, but more for the wider team is, you will have hundreds, thousands of consents all over New Zealand. So, just that burden, is it a common issue throughout your sites throughout New Zealand, or is it in particular here in South Canterbury, or Timaru in particular?
Ms O'Rourke might be all right, can have a go, but Ms O'Rourke first.
No, I don't think it's particular to Timaru District. I think it is a case nationally across all consenting sites that there is generally quite a risk-averse approach. And every resource consent is, it starts at 20 working days, but obviously it is generally more than that. So it is quite a delay to those projects. Nationally, yes.
And just to pick up on that, sort of probably, it is variable between districts though, because next door to us we've got, well, almost next door, but one, we've got Selwyn, which is sort of the gold standard as we see it, in terms of we've got a outline development plan and effectively a zone there. So that's sort of what we're aiming towards.
Thank you, Mr Burdett. Paragraph 44 of your evidence, you talk about the annual community meetings.
Yes.
You've had one recently in May.
Correct.
Which was attended by 10 individuals. Who normally attends these meetings? Is it the same people attending every year? And what are you talking through if there's no complaints?
Yes, sure. Nothing, we just feed them. So we actually invite all the surrounding neighbours, all the local farmers. We also invite Environment Canterbury. So we generally every year get a representative from Environment Canterbury come along, and other local key stakeholders as well. So there's generally an invite list of about 35 to 40, but we normally see. I think I've been doing it now for a couple of years. Coming out of COVID, we obviously delayed them out of COVID. So and we had about 6 people previous year and 10 this year. Local farmers, so we take them through what's been happening at the site. We take them through, from an environmental perspective, we take them through how we're tracking against our consents. They are particularly intrigued around noise and hearing and seeing about that and what we're doing. They're keen to understand from a transport point of view because our tankers are on their roads quite a lot. We share what we've been doing in the community, so our Hapori program does a lot of initiatives in the community and a lot of fundraising, etc. So we share a lot of information around that and our school visits. And then ultimately we just provide them an opportunity to ask us a lot of questions. They're very keen to understand around the longer term plan for Fonterra. We also have shareholder general meetings as well, which are led by the national team and the on-farm team. So a lot of the on-farm environmental discussions occur at that side of it. It's really about the Clandeboy site and what we're up to, and how that they can support us to send positive messages out into the community about what we're doing.
It sounds like a really effective liaison tool. And so in terms of the local farmers, are they joining adjacent land? Are they landowners?
Yes.
Yeah. Okay. And so you get a regular attendance from those adjoining landowners?
Yes, that's correct, yeah.
Yeah, great. Thank you for that.
Mary, just picking up on those community meetings, is that something that's purely a Fonterra initiative, or is it a requirement of a resource consent? It's somewhere in the system.
It is part of our environmental management system that we engage with our community. Yes, and that one way of doing that for us is to hold these annual community meetings. Yeah.
So a company initiative as opposed to one that's been imposed on the company by a council in a consent condition.
Yeah, it's under the ISO 14001
Okay. No, that's
Environmental
fine.
Act.
Thank you. And just also, have you shared with the local farming community your request for a special zone for Fonterra?
No, I don't believe we have. No.
Thank you.
Thank you. So we'll now have Mr. Chilton. Who, to state the obvious, is addressing air discharge, which is, of course, is a regional council matter, but it obviously brings in the reverse sensitivity issues and the interface between district and regional council matters as he discusses in this evidence. So.
Good morning.
Mr. Chilton. Look, just it would help us if you just give us a quick summary of your evidence, and then I'll see if there's any questions. Thank you.
So I guess the purpose of my evidence was to talk to reverse sensitivity air quality effects associated with Fonterra's Clandeboy operation. So I talked through the context for reverse sensitive air quality effects, which increases the sensitivity of an area as necessary. So reverse sensitivity air quality effects occur when there is a new activity, increase the sensitivity of the area as necessary to discharges from a legally established industrial activity. And this is a key component of Fonterra's submission. And in my evidence in chief, I refer to and highlight the issue in terms of its significance. I also point out that reverse sensitivity is a key issue in several of the Ministry for the Environment Good Practice Guides relating to air discharges, as well as providing an example of a personal situation where I've been involved with when I worked at the Regional Council in Auckland many years ago, where that activity came to fruition and it resulted in the industry needing to shut down as a result of land use zone changes around it. I also highlight policies in the Canterbury Air Regional Plan, which are particularly relevant for the industry when seeking to renew near discharge permit, which place an onus on the industry to monitor and respond to those changes in the receiving environment, such as through this district plan process. I go on to talk about the nature of the discharges from the Clandeboye site. It holds a number of resource consents for the discharge of contaminants into air. And I describe the general compliance of those, my understanding of compliance with those consents, including the understanding that there hasn't been any recent complaints regarding odour or dust in the last 5 years, and it's substantially met the requirements of those consents. I touch on the future development that Mr. Williams has gone through in terms of the biomass conversion to enable the reduction in greenhouse gas emissions, and noting that this would likely require an application to the Regional Council to vary the conditions or replace the conditions of its air discharge permit, which would require an assessment of discharges to air, including considering whether there'd been any change in the receiving environment at that time. I talked through the responsibility for the regulation of air discharges, which in terms of industrial activities is largely the responsibility of the Regional Council. However, there is an overlap with district councils in terms of amenity provisions for odour and dust, which is managed through land use. And as I note, a key method for industries to manage residual or unanticipated odour or dust effects is ensuring good separation distance from sensitive activities. In this instance, most notably rural residential dwellings, which is best achieved, in my view, through appropriate recognition and management through zoning provisions. I touch on the element of the Section 42A report, which sought clarification on a few matters regarding separation distances, specifically relating to the industrial wastewater land, where I provide justification for a setback of 250 metres and describe the geographic extent of that. So I guess in summary, I highlight the importance of managing reverse sensitivity air quality effects. Fonterra's proposal for a special purpose zone, as well as other submission points relating to reverse sensitivity effects, address this complex issue, and the establishment of zone provisions that recognise and address reverse sensitivity also address the objectives and policy direction of the Canterbury Air Regional Plan, which will be a relevant consideration for any of replacement air discharge permits that the site would seek. So happy to take any questions if that helps.
Mr. Chilton, just other than the issue of Fonterra seeking, based on your advice, a separation distance between, presumably that's between the Fonterra zone boundary and sensitive activities within the rural zone, is that
so the separation,
how it works?
The separation distance that was being clarified by the reporting officer was specifically in relation to the irrigation land. And so the issue that you can have is odour effects from the spray irrigation of wastewater to land. So there's a figure in my evidence in chief that sets out that. So it's more looking at the irrigation land per se than the manufacturing site itself.
Is that not addressed through the regional council provisions, or are you seeking are you suggesting a land use rule that would prevent owners of rural land that is adjoining the Fonterra irrigation wastewater sites imposing a 250 metre setback in relation to those properties?
I'm more just responding to a request from the reporting officer to provide clarity and justification on the setback distance. The original submission, I believe, sought 500 metres, and my recommendation was 250 metres in relation to that. So my evidence is constrained to that. The conditions have setback requirements in terms of where residences may be, and it's more of an issue in terms of land use zoning then if there's further encroachment of additional residences around the irrigation land. The figure in my evidence in chief highlights a number of what I've identified as existing residences around the site at the present, and obviously that becomes more restrictive as more residences, if more dwellings were to be established around the boundary.
And have you looked into whether that's likely, that more dwellings might be established around the boundary of those particular sites?
I haven't looked into whether that's likely per se. I'm aware many councils have conditions allowing a residential dwelling per land parcel. I've been involved in a number of cases like that, but having grown up in a rural area, I can speak to observations over time that, you know, there is change. There's dwellings routinely go in to rural land. You see lots of new houses around the place. So while I haven't specifically looked into that, my observations, dwellings do go in and around the place in rural land. They don't stay static.
Okay. But in terms of actually establishing whether there is a reverse sensitivity effect, you're not suggesting there is one currently that you've evaluated?
I'm not suggesting there's one currently. I'm suggesting there's a need to and an obligation on the company to manage that, which is set out in objectives and policy framework through the regional plan, and then that would need to identify areas around their site and seek provisions that help to manage that from not occurring. So the idea of reverse sensitivity is to try and avoid it by having provisions in through processes such as this one here as a mechanism for doing that.
So the rural zone itself, in your view, doesn't do enough to manage that reverse sensitivity effect?
I'm not aware of it having specific provisions that relate to specifically to the wastewater irrigation activity.
Are the issues that might relate to Fonterra, are they any different in your view from an odour perspective than other discharges of dairy waste arising from farming operations? And can you explain how they might be different and require a different response?
They are quite different in scale. Dairy farm activity may have a dairy shed, for instance, where it's got wastewater that's then irrigated to land. Different in nature, the type of wastewater that's being treated, and the sheer scale of the irrigation land. I mean, in terms of a dairy shed effluent, you're not talking the same level of land requiring irrigation, and a farmer can often shift that around the place to avoid sensitive neighbours, where in this instance I think you can see the extent from the figure that I've provided, the area that Fonterra needs to have available for irrigation to land. There's rules in the consent that it has for that regarding setbacks from residential neighbours, to the point that if that land becomes compromised, then it becomes difficult for the site to operate and discharge its wastewater in a way that meets its consent. My experience with a number of Fonterra sites, the extent of irrigation land is a significant constraint on its operation in terms of being effectively able to deal with its wastewater.
Okay. Thank you.
Just to continue that setback discussion, there's an addition obviously in the S4, number 4, on no new sensitive activity may be established within, and your recommendation is 250 metres from the boundary of any area used for the discharge of industrial trade waste at the Fonterra Clandeboye site. But in the report also, that talks about the economic cost of the proposed setback rule above may include the reduced development of potential of land within the general rural zone. Do you think when you look at that particular site, do you think that is the case, that there could be an economic cost?
That's well outside my area of expertise. I'd suggest I'm not an economist in any way, shape or form to be able to talk to that.
Because you talk about 500 versus 250, so yeah, I know that's not your area of expertise, but...
My involvement was this in terms of looking at other activities which other sites that Fonterra has where they discharge wastewater of a similar nature to this, what sort of feedback would typically be involved in that. So that's where the 250 has come through from my experience. And I didn't necessarily support continuing with a 500 metre setback. Thank you.
Thank you. We'll now turn to the next Mr Smith, which is Paul Smith this time. So.
Good morning, Commissioners.
Good morning. Only just. If you could just give us a very short summary of your evidence and then we'll see if there's any questions. Thank you.
Cool. Thank you. So my evidence, I'll probably focus on my executive summary there. So the purpose of from my understanding, the purpose of the proposed special purpose zone is to recognise the importance of the Glandeboy dairy manufacturing site and to ensure that the existing dairy processing activities and facilities are enabled to operate and develop on an ongoing basis while managing the potential effects on the surrounding environment. I found that in most instances the standards are very similar, well the CDMZ standards are very similar to the current general industrial zone standards. There's a number of key positive aspects about this from a landscape side of things, is that the height limit of 20 metres is much lower than the 35 metre height limit currently. However, we do have the instances where we've got a 65 and 50 metre height limit, which do focus on the existing built form. Then we also have the 9 metre height limit above the school site. We've got a 15 metre height limit above the site where the wood burning facility, wood biomass facility will go. So that's similar to the rural zone as it currently stands. The extent of the zoning has increased by 5.4 hectares in area to the north in that area. There are no recession plane standards, which is unlike the general industrial zone. But the increase for the setback has been increased to 5 metres where it was previously 3 metres. And there is no requirement for additional roadside planting for permitted activities. So when undertaking my assessment of this, again, the noticeable lower buildings within the site will remedy potential landscape and visual effects that may otherwise result from taller buildings within the site. The proposed 65 metre and 50 metre height limits closely align with the existing taller buildings. Therefore, they'll only provide for small upgrades and maintenance of these buildings. So I consider that they will not result in any adverse landscape or visual effects. The increase in developable land essentially to the north will have very low to low degree of adverse effects on open space values. Further development within that space will be well clustered with the existing development, and it's well located away from the Waihi Te Puna overlay and is appropriately located away from the Orari River, which also has high natural character and cultural values as well. The removal of the recession plane, but increase of the overall setback and reduction overall building height will not result in more dominant built form being located or adversely shading the affected neighbouring properties. I think the formatting of this paragraph here was a bit funny, but I consider that the roadside planting for permitted activities is not required because the general industrial zone landscape requirements for the site are relatively defunct as they provide very little in the way of mitigation. This is clearly seen on site by the planting along Milford Glandyboy Road that was undertaken as part of fulfilling conditions of the consent when compared to the voluntary planting undertaken by Fonterra along Donahue Road, and the fact that the Fonterra site has formed part of the receiving environment for 120 years, so it's an anticipated node of development within the rural environment. So overall, I consider that the proposed CDMZ policy provisions and the outlined development plan allows for a very similar landscape outcome to the general industrial zone and general rural zone policy provisions for the site, but where there are differences, I consider that the proposed zoning, when compared with the current zoning, will have a very low degree of adverse effects on the landscape values of the receiving environment.
Very much, Mr. Smith. Can I just clarify on the height? So you, is it your understanding that within the CDMZ zone that there are lower heights being proposed than what would be permitted in the general industrial zone? Is that correct? Is that
Yeah, that is correct.
so? Is it your understanding that aside from the taller structures that exist currently on the Fonterra site, there's not likely to be a need for any additional height within that zone, or that would simply be assessed on it with a resource consent type?
It'd be easy, if you have the graphic attachment in front of you, and if I'd probably turn to page 8, that'd be the easiest page to talk to on this. So I won't rush you.
Right, I'll just find those.
We just have it in a pack. Can you just lift it up so we
Oh.
can see what it looks like? Oh, yeah.
I found this page here probably easier to talk to because you can see the underlying aerial with the buildings on it.
Thank you.
That's right. So you can see there where the 50-metre height limit is and the 65-metre height limit is, and those are they are closely aligned with those existing taller buildings. But as soon as you move away from those taller buildings, you go to a 20-metre height limit, where the existing...
Excuse me, can I just clarify? Those existing taller buildings, when we were on site, we did notice the very tall silos. Is that what you're referring to?
Yes, yeah. I am.
Yes, so they're the 60. There's 65, is it?
65
Yes.
and 50.
Excellent, thank you.
And so as soon as you move outside of that area, but you're within the area that is currently developed, which is around 41 hectares, that has a 20-metre height limit over it. So that's 15 metres below the 35-metre height limit as per the current general industrial zone. And where you've got the, I guess, greenfield development that may happen in the future, that is a 15-metre height limit. And so that, for a comparison, and because I'm more familiar with working on the Synlait site than the Fonterra site in Selwyn, is that they've done a similar design where you have your taller buildings clustered in the middle and you work downwards in a pyramid shape closer to your neighbours and closer to the surrounding roads.
Thank you. Do you have any questions?
So yes, just so the buildings on the perimeter of the site, how high will they be?
The current height of the existing buildings, or I don't know how tall those are, but they do fit underneath that 20-metre height limit. Okay, so I was in consultation with the team at Fonterra to assist with making sure that the existing buildings do fit within these height limits as they currently stand.
Okay, thank you.
Thank you. You mentioned distance from the Waihi Tupuna. overlay.
Yes.
Could you clarify what that distance is for me? Is that on a map somewhere for us to?
Yeah.
If you could
So if we
direct us to
probably
that map?
Turn. If you go to page 5 of the graphic attachment, you can see the overlays on that plan there. If I get this, the general industrial zone is currently within the Waihi Tapuna SASM5 overlay, but where the new development will be located is north of Rolleston Road, and Rolleston Road is the boundary to that overlay. So that overlay
I can see the SASM 22 to the west.
And so that's associated with the river there.
Yes.
Can you see the black dots?
Yes, I can. I
So
see.
that's the, number 5.
Ah, I see. Yes, I can see that now. Yeah.
I think.
Okay, so that SASM does come straight up to the boundary.
Of Rolleston Road, so the majority of the site is located within there.
Within that?
Yes, it is.
Yes, okay.
And
what was your comment in relation to that?
Well, the extension of development is located beyond that. So it's not directly impacting on that overlay and the cultural values that are associated with that overlay.
Great, thank you.
That overlay is quite vast. I've forgotten my river names, and I apologise for commissioners. Commissioner Solomon, I'm probably aware that you'll be aware of which rivers they go to, but it extends from the coastline inland, and I think they've used Rolleston Road as a very good boundary, and it's associated with food gathering for those rivers and along the coastline.
Thank you for that. I have no further questions. Thank you, Mr. Smith.
Oh, thank you very much.
Thank you, and we'll now have Mr. Hay on noise.
Good afternoon, Commissioners. Sure. So Fonterra currently operates under a resource consent that permits stipulated levels of noise at the boundary of existing dwellings. The noise levels are essentially 5 dB greater than the proposed Timaru District Plan limits. It is not possible for Fonterra to internalise its noise levels within the proposed Clandeboye Dairy manufacturing zone. Should a new or altered dwelling lawfully established near the site, Fonterra would be unable to comply with the proposed district plan noise standards at that dwelling's notional boundary. To prevent this reverse sensitivity effect, it would be appropriate to establish a noise control boundary around the site, along with a set of appropriate controls over noise emissions and building controls such as sound insulation rules on new or altered buildings that include sensitive activities seeking to establish within the NCB. This framework would protect Fonterra's ability to operate on its established and mature site while providing certainty to Council and to the local community as to where future noise effects lie and how these will be responded to. And NCB also gives effect in part to proposed CDMZ Objective 2 and CDMZ Policy 3, which recognise that reverse sensitivity effects on the Clandeboye site must be avoided. So if you have any questions, please.
Thank you for that. Mr. Hay, just as you'll be aware, the panel did a site visit, and so we're quite familiar with, we went on site obviously and got an appreciation of likely sources of noise that might eventuate from the site, but also just the surrounding land uses. And I just wanted to do a bit of a reality check with you about how realistic is it that new or extended dwellings of any number might establish surrounding the site within the area that you consider might be impacted by noise?
Yeah, I think my approach would be similar to some of the evidence you already heard this morning. There is the potential for people to lawfully establish dwellings on rural land. I've certainly seen that in close proximity to other both Fonterra dairy sites and non-Fonterra dairy sites around the country. And the current proposed district plan does not set any limit to prevent people from lawfully establishing close to an area of effect that would cause reverse sensitivity, and does not require any particular sound insulation performance, for instance, to mitigate such an effect. So I think for Fonterra and for the sake of future potential residents, it is an appropriate thing to do to establish such a framework now. It wouldn't necessarily stop dwellings from going in, but it would ensure that people had a minimum level of amenity that protected them.
But have you done any analysis on identification of land surrounding the Fonterra site that is already owned by and controlled by Fonterra? The location of roads and other farming activities, dairy sheds and the like, the size of allotments compared with the permitted rules in the plan for establishing dwellings, in order to identify how many dwellings might be likely to be established within an area that might be affected by noise from Fonterra.
So I certainly haven't looked at, for instance, location of dairy sheds or such things. They're not a noise-sensitive activity, so I wouldn't be concerned about those. And I would have to defer to the planners and to Fonterra as to the land parcel size of non-Fonterra land. There are 3 quite large contiguous areas of non-Fonterra land that are within the proposed noise control boundary, to the northeast, the northwest and the south of the site predominantly. And some of those land parcels are relatively large. So it's really about preventing a future effect. And for instance, while if someone stayed within the current permitted development size, that might only be a handful of dwellings which could potentially establish. I have seen around a number of sites in both the South and North Island, both Fonterra and non-Fonterra, where people have sought to subdivide their farms into smaller allotments, such as rural lifestyle allotments, which is a substantial increase in the number of potential dwellings within a zone of effect.
Have you considered other alternative forms of regulation that might control the number of dwellings within the area, rather than the creation of a noise control boundary and insulation rules, such as setbacks or minimum lot sizes for dwellings?
Not for this site. We did look at that quite closely for a North Island site, because the district plan in that case already had a rule framework that used setback distances and minimum lot sizes. in that instance, the council, even though it already matched their rule framework, decided they didn't particularly like the form that those rules took. You know, it was a little bit blunt, I guess, you know, and I think looked alarming for them. So in that case, the district actually opted for the noise control boundary and sound insulation rule as an alternative. And it has to be said that the purpose of the noise control boundary isn't to stop potential permitted dwellings. It's to, one, flag to the landowner that there is a need to take some kind of action to prevent reverse sensitivity, and secondly, to ensure that any occupant of that house ends up with an appropriate level of indoor amenity for the particular location of that dwelling. So as you get further away from the Fonterra site, the likelihood of needing to undertake any particular level of sound insulation reduces. As you move closer in, then it increases.
Perhaps we'll ask questions of Ms. Tate. She can perhaps talk us through the number of likely dwellings that might be established within the rural zone surrounding the Fonterra plant. But what about other alternative mechanisms? For example, advice notes within the plan. We've also heard Fonterra tell us that they liaise with their community, advising their neighbouring landowners of the potential noise. I mean, they've clearly started a conversation about that. Aren't they appropriate alternatives relative to the scale of people, of likely impacts?
I mean, obviously I think communication with neighbours is a good thing. My experience elsewhere has been that people don't necessarily refer to the district plan, in particular to advice notes, and take those with any great weight. If there's not something in the district plan that would actually force action, I don't think that it, with respect, really is worth anything. And in terms of number, I think obviously as you get more sensitive activities moving close to something that it creates noise, you significantly increase the potential for conflict. But by the same token, I have observed quite intense conflict with just one or two neighbours. It depends how motivated they are and how much resource they're prepared to devote to pursuing a grievance or a perceived grievance.
What about notes or notices on land information memoranda? Do you have any experience with that as a technique for alerting potential future residents to noise sources?
Pretty mixed, I would say. Some people, look at a limb quite closely when they're making a purchase or development decision, and some people ignore them completely. And that doesn't apply just to dairy sites. I've been involved in disputes between neighbourhood shopping centres and subdivisions where people have purchased a residential site beside what was very clearly a commercial site that was vacant, and then have been surprised and disappointed to discover that there was a commercial site developed and that it created noise. And yet that was marked on the limb, and there was a hoarding up on the site, and you can't rely on such things in my experience.
And is the noise contour boundary and requirements regarding insulation likely to stop those sorts of complaints?
I think with the added trigger that it requires some kind of resource consenting or building consenting attention from the council, that ensures that people don't stumble into this situation without their eyes open. And the sound insulation rule, in our experience, is very effective at ensuring that people get appropriate sleep protection amenity, which is the main source of complaints usually.
Okay, thank you.
No, no question.
Thank you. The questions I had have already been traversed with Commissioner Robinson. I guess I just wanted to check with you in terms of the scope of your evidence. Would it be fair to say that it was speculating on future scenarios that might occur in terms of a preventative regime for Fonterra without any actual known impact, analysis on any known impacts or effects?
Yeah, so we've got, I think that's largely true. There is one dwelling that is currently inside the proposed noise control boundary, and generally speaking, when we do monitoring at that dwelling or very close to that dwelling, compliance is achieved. There are, occasional times when the noise level is closer to what the model predicts, and that seems to be largely based on the intensity of tanker movements in the nearby parking site. So while more often than not compliance is achieved, it's certainly a site where, and in an area where I'd be reluctant to see new or extended dwellings going without some kind of attention.
Further questions for you, but thank you very much for your evidence.
Thank you.
And we'll now turn to Ms Tate, who I think has a summary as well.
I was going to say good morning, but we've flipped over. Good afternoon. I do have a summary statement. I think you should have a copy of that in front of you. This responds to some of the questions that Mr McLennan has included in his summary statement. So I'll just walk you through this quickly, maybe. So the first query that Mr McLennan had was with regards to offensive trades, and as the special purpose zone stands, offensive trades would be treated as permitted activities, and the general industry zones are discretionary. And I've just made some comments here in response to Mr McLennan's observation. So there's already offensive trades on the site. There's a wastewater treatment plant, DEF plant specifically, and disposal of sludge, and there's also a recycling facility which probably loosely fall under refuse collection and disposal. These activities have resource consents from the Timaru District Council and from ECAN. For context, the General Industry Zone Policy 5 sets out those matters that are relevant to the consideration or the ability to establish an offensive trade in the general industry zone. And I guess I've just summarised there that they are limited to amenity effects, which would probably correspond to landscape consideration of the landscape effects, odour effects, and possibly noise effects.
Excuse me, Ms Tate.
Yes.
Could I just get you to pull your microphone a bit closer, just so we can hear you just a little bit better? Thank you.
Sorry. As they are discretionary, there is no, I guess, reason or necessity for council to include, I guess, matters of discretion in inverted commas, but they have done so. So it would seem odd in a consent environment not to confine the scope of the assessment to those matters. So noise generated at the site, we've just heard from Mr Hay. the noise generator is already managed by Resource Consent 3145, issued by the council, Timaru District Council, and Fonterra is seeking to formalise that through a noise control boundary. Mr Paul Smith has spoken to the merits of the landscaping required under the general industry zone, and Mr McLennan seems to concede, although he'll have to clarify, that Standard 6 or related landscape rule has limited value for the Clandeboye site. And then finally, odour effects. Mr McLennan, Mr Chilton and I are all in agreement that ECAN have the primary responsibility for managing odour effects. It is acknowledged that council have a responsibility with respect to setbacks of sensitive activities, which I'm sure will come to as we in due course. But the separation consideration, that's a separate consideration to whether or not offensive trades on the Clandeboye site are appropriate as a permitted activity. I just want to note that further offensive trades are not anticipated. They'd fall outside Fonterra's core business, and offensive trades are limited to those that fall within the definition of dairy processing activity. So we couldn't set up a tannery or a foulmongering activity or a abattoir or anything like that on the site. It would fall outside of what is anticipated under the CDNZ, the Special Purpose Zone. There are some practical considerations with respect to offensive trades. The nearest residential neighbour is 300 metres from the boundary, that's south-east. And also, if approved by the panel, or if the panel votes favour in the idea, there's also a noise control boundary, changes to GRUS P5 and changes to GRUS Standard 4, which I imagine we'll discuss shortly, that would also act to limit or prevent sensitive activities establishing within the operating sphere of Clandeboye. I do, however, acknowledge that the dairy, the CDMZ is looking to push north of Rolleston Road, and that is closer to the kindergarten. So I have made an additional amendment to Rule 1 and Rule 2 of the Special Purpose Zone, which would mean that any offensive trade establishing on 37 Rolleston Road or 2 to 10 Kotuku Place would be discretionary. So I do acknowledge that there's a sensitive activity there that needs more scrutiny if an offensive trade were to establish on that side of Rolleston Road. In conclusion, I see little merit in applying an unnecessary consenting burden on the Clandeboye site where there are other mechanisms in place, including the requirement for ECAN consent to manage the effects of any offensive trades relating to dairy processing activity. I think that's a really important caveat to remember. Next, Mr McLennan asked about ancillary activities and whether or not effectively all of the activities that wrap around Fonterra's core manufacturing business would be captured by ancillary activities. I think that would be a relatively perverse interpretation of ancillary activities, particularly when there's other specific rules in the plan that might address those activities. And if that were the case, then offensive trades on the Clandeboye site would be permitted because they are ancillary to the manufacturing of dairy products. So I think there are sensible limitations to how ancillary activities can be applied. Next, I just want to talk about the objectives and policies. So I guess Mr McLennan's question in brief was, what are the issues with them? I do not necessarily consider that the general industry zone objectives and policies are incompatible with the activities at the Clandeboye site. I just don't think that they are relevant or serve any useful purpose. Objectives and policies guide resource management outcomes in two ways. Firstly, they inform rules and standards for a zone and define what is permitted or generally anticipated. And secondly, they guide decision making in the event that resource consent is required. With respect to the rules, I have set out my concern with the general industry rules and how they relate to the Clandeboye site in my evidence in chief. But I think there's a really important point here that I make at paragraph 8, that the special purpose zone framework provides Fonterra with a much narrower scope for establishing industrial on the site than the general industry zone. Under this CDMZ, I've defined it as here, Fonterra may establish activities relating to dairy processing. All other industrial activities are discretionary. Whereas if the Clandeboye site were to retain its general industry zone, any type of industrial activity could be established on the site, which in my opinion is contrary to the urban form outcomes that the council are trying to achieve by consolidating industrial activities in the general industry zone. And that's consistent with the directions of the Canterbury Regional Policy Statement and the Growth Management Strategy for Timaru. The limitations proposed on activities by the CDMZ inadvertently improves urban form outcomes for the council. If I have interpreted Mr McLennan's summary statement correctly, we are in agreement that general industry zone standards 1, 2 and 6 are not appropriate for the Clandeboye site. As Clandeboye is not in close proximity to a residential zone, then standards 4 and 5 are not applicable, and that leaves standard 3, which relates to setbacks, which I do consider to be of some relevance, but note that the special purpose zone applies a larger setback to boundaries adjoining a rural zone. On this basis, none of the standards in their proposed form are relevant to the Clandeboye site. On the basis of my discussion in the preceding 2 paragraph, it then stands that the objectives and policies which have guided those rules and standards have relevance. Perhaps more importantly is the relevance of the general industry zone objectives and policies in the event the resource is required. The Clandeboye site is not located in an urban environment, it is not near a residential zone, it is not reticulated to public services, and it is not intended for activities other than dairy processing activities. So while it could be argued that development on the Clandeboye site wouldn't offend those general industry zone objectives and policies, nor can it be said, in my opinion, that the objectives and policies support the intended outcomes of the Clandeboye site and guide decision-making in the event that resource consent is required. Lastly, with respect to the MPS HPL, I set out a pathway through clauses 3.6 and 3.11 in my evidence in chief. But I just want to set out here more explicitly that I'm satisfied that the proposal to extend the special purpose zone onto highly productive land is consistent with the relevant HPL objectives and policies. And I should just qualify that it's not necessarily consistent with those objectives and policies, it meets the exceptions that are provided for in those objectives and policies. Given the scale of the significance of the Clandeboye site, the inability to relocate the operations, the need to rezone this land to meet the requirements of Clandeboye's operations, and therefore meet district demand for industrial land, and the decarbonisation benefits associated with the biomass conversion project, I consider that the expansion of the CDMZ onto HPL is appropriate despite not prioritising the land for land-based primary production. Lastly, I would note that the effects of climate change are a Section 7 consideration, and the risks from natural hazards are a Section 6 consideration, which will become more frequent as a consequence of climate change. When the MPS HPL is read in the context of the purpose and principles of the RMA, there is a compelling case to forfeit a small area of land to achieve Fonterra's decarbonisation objectives. And then lastly, at paragraph 16, I'm happy to engage further with Mr McLennan with respect to the rezoning, and we have a meeting set up after this. I did have some additional comments based on queries that you've asked, but would you like to ask me some questions and I can...
You to respond to those if you've got notes. Thank you.
There was actually a point that was raised yesterday. I watched over the initial part of the hearing yesterday, and it was whether or not the Canterbury Regional Policy Statement, what is the policy, I guess, environment for dealing with reverse sensitivity effects? So I've had 24-ish hours to kind of mull that over. And if you're interested, I could give you my opinion. So I think that Chapter 5 of the Regional Policy Statement is relevant. And if I go to Objective 5.2.1, then that it seeks to avoid conflicts between incompatible activities. And Mr McClellan touched on this yesterday as well. To a large degree, the Regional Policy Statement touches on both sides of the reverse sensitivity effects argument. So it acknowledges that they exist and that they need to be avoided or managed. But it also, I guess, acknowledges that if you put incompatible activities in proximity to these effects generating activities, then they will experience those effects themselves. So it's not just about the effects on Fonterra, it's also about the effects. Effects that are typically elevated for the types of activities like Fonterra's Clandeboye site, and what implications they would have on an individual or a business, whatever establishes in its operating sphere. 5.2.2 and 5.2.3, they talk about infrastructure, so I don't think that they're relevant. I think when we delve into the policies, I think it starts to make a distinction between urban and rural environments, and I think that's particularly relevant to how the issue of reverse sensitivity is sort of captured. So 5.3.1, my reading of that is that it's an urban policy. It's designed to guide urban development in our urban centres, and there is effectively no reference to incompatible activities or reverse sensitivity in there, notwithstanding that reverse sensitivity can happen in urban environments. I'll move on. 5.3.2, that relates to the wider region, so that would capture both urban and rural environments. And at 2B, that states reverse sensitivity effects and conflicts between incompatible activities, so it starts to separate out the issue. Should be avoided or mitigated, and that includes identified mineral extraction areas. So I think that makes it clear that we're looking at not just the urban environment, but the whole region. 5.3.3, again, I think that has an urban focus that's focused on sufficient capacity, and it doesn't refer to the issue at hand. The 5.3.4, to do with Papakainga housing in Marae, this is relevant. These activities typically are in rural environments. The policy hasn't taken a reverse sensitivity approach to these activities, but it has talked about adverse effects on the health and safety of people are avoided or mitigated. So it is clearly turning its mind to the fact that if these activities set up next to activities that do not serve the occupants or may harm the occupants, that's a relevant consideration. Then we go into a suite of policies about infrastructure, which I will flip over. And then if we get to 5.3.11 and 5.3.12, they are rural policies in effect. So community scale irrigation, stockwater and rural drainage, so that make the rural environment tick. There is a policy there about avoiding development which constrains the ability of this infrastructure to operate, be maintained and upgraded. So I think the policies are starting to turn its mind to what is the purpose of the rural environment, and how can we let activities intended to establish in those environments or the rural environment operate without being inhibited by sensitive activities. Lastly, 5.3.1.2. So this is where I think, and we discussed this in hearing A. So 1 obviously talks to avoiding development that forecloses the ability for the use of land for primary production. But but the purpose of 5312 as a whole is to do with rural production. And I think rural production occurs on a continuum, which the policy does recognise. There's no explicit reverse sensitivity clauses in relation to employment activities in that policy. But I do come to that in my evidence. It almost seems a bit perverse to allow for these activities that support primary production to establish and then not, I guess, protect them or provide wraparound policy that enables them. I mean, there's a reason why Fonterra's out in the middle of the country. It understands its operations. It understands it's going to emit effects beyond its boundaries. They have consents for effects beyond its boundaries. So I think that's where I don't think that there's explicit protection in 5312 for employment, but as Mr. Williams touched on earlier, there is 1435, which is the relationship between discharges to air and sensitive land uses. And that is explicit to avoid encroachment of new development on existing activity discharging to air where the new development is sensitive to those discharges unless any reverse sensitivity effects can be avoided or mitigated. So that's my 2 cents worth on the framework.
Thank you.
If that's at all helpful. I did have another, if I can just flick back to my summary, I scribbled some notes at the end. So there was some questioning, particularly directed to Ms. O'Rourke and Mr. Burdett about the burden of consenting. And I think hopefully what you took from that is it's really the burden on those day-to-day activities, and that is really all the special purpose zone seeks to cover as permitted. So large expansion projects that would sit outside the ODP would require resource consent, and Fonterra acknowledges that that's appropriate. And I think Mr. Williams touched on this, Starfield's just up the road, they have a special purpose zone, the dairy processing zone, and it effectively enables Fonterra to go about its business in much the same way that we're seeking here. So those day-to-day things aren't captured by the district plan.
And is this zone that you're proposing based on that zone? Are there similarities?
Yes, there are similarities. There was a question, I'm not sure which commissioner it came from, sorry, but about whether or not Fonterra experiences is it a Timaru issue or is it a national issue? I think Ms. O'Rourke said it's a national issue, but Fonterra engage with these processes. They understand their operations. They've been operating for a really long time. They're engaged in these processes. I guess they know where the pinch points are on their business, and that's why they engage with these processes to try and ease some of that regulatory burden. Lastly, there's been a bit of questioning. I've captured it under the heading of the threat of reverse sensitivity, and there was a question about the real threat. I guess taking a step back, Fonterra's concern about reverse sensitivity effects doesn't come from a place of imagination, for want of a better word. It's a very real impact on their business. So, and it's often forecasting potential threats. They're not looking to prevent someone from establishing a house on their property. That is a neighbour's right. But I guess the threat becomes potentially a bit exponential when resource consent applications are made. So if someone applied to subdivide the land, or if someone looked to set up, like home care, for example, is a permitted activity in the general rural zone. But if that activity doesn't comply with the permitted conditions, then it triggers resource consent. So it's not necessarily about what's permitted in the zone and whether or not the general rural zone itself has sufficient provisions. It's about acknowledging that people are entitled to apply for resource consent and what the impact of those resource consent or the activities proposed as part of that, what they might do to the Fonterra operations.
Ms. Tate, if I just, but in terms of, I mean, this has all got to be assessed in the framework of Section 32 of the Act, and so we are looking at proportionality here. So the reality or the real world check is quite important in this context because effectively there's a cost that's being transferred by Fonterra's operations onto a community by imposing restrictions, additional restrictions in the rural zone to limit, potentially limit the number of dwellings, potentially limit where those dwellings can be established or impose the cost of additional insulation if they are. So this is both just talking about air, odour and noise. And who bears that cost? And is the response proportionate to the risk? Hence my question of Mr. Hay. I mean, what sort of analysis has been done to determine how many activities are likely to be impacted within these areas? Is the response proportionate? And you might better point me in the direction. I mean, you've helpfully provided a Section 32AA analysis to support the zone, but where's the 32AA analysis to support the additional restrictions that Fonterra is seeking to be imposed on the location of dwellings and or insulation requirements? Where do I find that?
The noise control boundary, I guess Mr. Williams might tell me I'm wrong, but the purpose of this hearing or introducing noise at this hearing was to give the panel oversight of the Fonterra operations more fully. Obviously there's a noise hearing coming up, so we can look to ensure that the appropriate Section 32 analysis is done at that point.
But you've proposed it in your submission,
yeah.
So isn't that the time? I mean, you must, as a planning expert, have reached an opinion that this is an appropriate or the most appropriate solution for the rural zone, and this is the rural zone hearing. So where is the analysis that supports that opinion?
I haven't done it at this point. I was looking to do it at the point that we discuss noise.
Did you have any input into preparing the submission that Fonterra filed in relation to this, or was that purely just a corporate submission?
No, I was involved in preparing it.
And did you not look at Section 32 in terms of supporting a rule requiring restrictions on rural zone?
No. I would say that would be an unusual exercise for people to do at the point of preparing a submission.
Okay. Were there any other matters you wanted to just respond to, and then I'll just open the panel for questioning?
Open to questions.
Okay, thank you. Commissioner Day?
Thank you. If I could take you to, in your summary statement.
Yes.
Paragraph 7.
Yes.
Just so that I am clear on what you're communicating here, you've said that you do not necessarily consider that the GIS objectives and policies are incompatible, but that you are, and in the same breath you say you don't think they are relevant or serve any useful purpose. Is that a contradiction in terms? If something is not incompatible, then they could be said to be compatible and therefore relevant. And so I'm not clear, I'm not certain that you've provided the depth of policy or objective analysis there that's helpful.
So incompatible was the term that Mr. McLennan used. So I don't think that, particularly the objectives, I don't think that the activities at the Clandeboye site necessarily offend the objectives, but when it comes to the policies which are designed around an urban setting, I don't think they're relevant. I will come back to that word. I don't think they're relevant to Clandy. So all of the rules and standards that have flowed from those policies are intended to design industrial activities in an urban location, and they're intended to inform decision-making in an urban setting, and that's not the issue. That's not the case with the Clandy site.
So if you can take me through, in the general industrial zone, I'm just looking at the chapter.
Mm-hmm.
Could you take me through where the emphasis there is on urban, and why those policies are not suitable? Like if you take me through each policy, please, so that I actually understand what your opinion is here.
I'll just pull up the Ms. Hollier's version in the section 42. That's not it, sorry. I just want to make sure I'm working off the latest version from the section 42 author. So P1. So P1. Probably no directive that, or no indication that it's urban. And P2.
So sorry, just for GIS P1, industrial activities.
Yes.
Enable a range of industrial activities and associated activities where 1, 2
Yes.
and 3. Are you saying that nothing in there is relevant?
No, I'm saying that, well, yes and no. If you go back to my point that the zone, the site, the Clandy site is not intended to enable a range of industrial activities. I don't necessarily consider that that's relevant. I don't necessarily consider it offends or as this policy is inappropriate. I talked through ancillary activities on the same site in my evidence in chief. The Clandy site's made up of 12 parcels and 9 lots, so it starts to become a bit difficult to establish an ancillary activity on the same site. The activity does not include residential activities, that's fine, and compatible and complementary to the purpose, character and qualities of the general industrial zone. That relates back to objective 2. That's generally okay for the purposes of Clandy Boy.
Okay, so the statement in your summary evidence then, it sounds quite black and white to me, but talking through just one policy and you're deviating from your written opinion, it's just not leaving me with a lot of clarity around those statements.
But I don't think you read one policy, like you would look at, if resource consent was applied for, you would look at the full suite of policies.
Absolutely, but when I read a statement, I do not think the GIS objectives and policies are relevant or serve any useful purpose. That's quite a firm statement to say about a set of provisions relating to a whole zone.
Well, these policies inform the standards and the rules, and I think what we've established is none of the rules, that's a bit of a stretch. It's framing that this zone, or this site, sorry, is limited to dairy processing activities. So I think the narrowing of what, Clandeboye achieves through the special purpose zone is actually a benefit to the council. I don't think the council would want to see any old industrial activity establishing on this site, but I digress. I think that, so I don't think that they're relevant to the extent that they inform the standards and the rules to the Clandeboye site. Does that make sense? Because none of the standards are relevant to Clandeboye. They would all require modification.
Yes, I understand that. I think I'll leave that there. I've explored that as much as I can today, I think. Thank you.
I appreciate, I think I read somewhere that Kati Huirapa were contacted about the rezoning proposal. Or did I not read that somewhere?
No, I think in my evidence I say that there was no further submission from Arowhenua or from Ngāi Tahu in relation to the rezoning.
So that takes me to your paragraph 6.5.4 where you talk about the treaty and you say the Schedule 1 process provides for Section 8 of the RMA. But couldn't that be said about every application that goes through a Schedule 1 process? Or am I not understanding what you're saying here?
There are specific consultation requirements around a plan change or a district plan review. And then naturally what comes after those initial consultation, I know Arowhenua we're heavily engaged with developing the plan, and they would have seen, I shouldn't speculate, they may have seen Fonterra's comments on the draft plan where this was first raised at the special purpose zone. But then after that point, there's obviously a public participation process which Ngāi Tahu were involved in. So I don't think the request to rezone land is contrary to the principles of the treaty, and that there is an opportunity for Mana Whenua to be engaged in the rezoning of the site.
Okay, thank you.
Thank you, Ms Tate, for your evidence. Mr Williams, just before you close your case, I just wanted to I think the panel's clear in terms of what Fonterra's objective here is, and it's to find what is the most appropriate zone framework to accommodate Fonterra's activities and a more efficient and effective framework than what you are telling us is currently provided within the zoning options and the proposed plan. So that much is clear, but in terms of the discussion that we've had with Hilton, Mr Hay and Ms Tate around the additional regulatory responses that transfer costs to landowners in the rural environment and the rule framework that you're seeking there, we're a little bit lacking in substance in terms of the information we would require in order to make an evaluative judgment on the most appropriate outcomes. It's not clear to us what alternatives that have been considered in terms of the choices that have been made to promote setbacks, noise contours, insulation requirements. And I take Ms Tate's point that there is another, this is not the end of the process, but this is the hearing where we are considering the zone framework for the rural zone. So are you able to respond to that and help us fill in some gaps?
Yeah, look, and it might be able to come back to you either as a part of this hearing process or later hearing processes as well. I think the important thing to remember when this is particularly picking up on the probably two related points is the existing rural zone sufficient to manage the effect per se, and or who should bear the cost of the effect. I think it's important to remember here that we're dealing with an existing site, so we're not talking about future effects, hypothetical effects per se. There is currently a noise envelope and an odour envelope occurring at that site. So as Mr Hay particularly was quite clear on in the case of the noise control boundary, that's not about stopping people at all, and it's not about imposing, it's not a situation of transfer of cost, because as I see it, the effect is already occurring, protected by existing use rights. It's putting the appropriate flag into place with regard to if someone wants to develop a dwelling in proximity to the Clandeboye site, that appropriate measures will be put in place. So that's sort of where we see particularly the noise control boundary working. Odour's obviously got the awkward overlap with the regional council aspect as well, but I think the important thing to note on that, and I need to check it in relation to Clandeboye, but I'm certainly dealing with it with one other site at the moment, where the relevant Fonterra consents have setback requirements for particularly wastewater irrigation or odour creating activities. So in that scenario, one single dwelling on a boundary can have a quite profound effect on Fonterra by virtue of its wastewater discharge setbacks per se. Certainly I've done myself, and I'm not wanting to give evidence myself, but I've done Fonterra work for close to 20 years now. This is the first Fonterra hearing I think I've had where I haven't had a typically single dwelling owner come along to the relevant hearing we're in and express some concern or complaint around the proximity of Fonterra's operations to their dwelling. The good example of that relatively recently was the Studholme operation, where that's superficially driving past a similar rural environment, but there's actually a single dwelling quite close to that manufacturing operation, and that single dwelling in a practical sense, and picking up on some of the same things we're talking about, that can be the fundamental difference between a non-notified hearing process, which is quite, relatively speaking, quick and efficient, versus a limited notified hearing process, or potentially extending right out to a full notification process by virtue of that single dwelling being present there. So Fonterra, and this is not specific to Timaru at all, across the country, we have taken, Fonterra is taking a very proactive approach in terms of avoiding reverse sensitivity and really picking up in the context of Timaru the RPS themes in 5.3.12, 14.3.5, and Ms Tate set out the framework more generally, but which again have that theme of avoidance per se. So that's sort of where we see this, but I think, it's just coming back to where I began, I think the fact this is an existing site and the effect is occurring does make it a little bit different.
But all of that suggests, and if we accept all of that, that Fonterra is doing a good job in terms of its liaison with its community and managing its activities, and that might be why there are no, complaints and such. But that just raises an issue of proportionality. Like, is the degree of regulation that you're seeking in the rural zone to support the activities of Fonterra, are they proportionate to the risks, or the reverse sensitivity risks that you've outlined in this instance? I'm not talking about the generality of reverse sensitivity risk. And we went through with Mr Hay that, there are other alternatives that could be considered that may or may not have worked in other areas, but are they appropriate here, given the good relationship and established processes that Fonterra has with its community? Is there a different way that this should be approached rather than the form of regulation? And where's that analysis that's informed the outcomes?
Certainly noted for particularly noise to come in terms of which, particularly on the issue of noise, this hearing was just an introduction. We're appreciating that noise we dealt with later on. We'll obviously go away and reflect on that. I think in terms of a general overall comment, certainly in my submission, Fonterra is not, probably a trite proposition, not trying to overreach on these issues, as particularly the noise control boundary is a good example of that. But it's not about prohibiting otherwise anticipated activities in the rural zone. It's about flagging to those people and making sure they are aware of the existing operating site. As I said, this hearing process is a bit easier in some respects because we're not talking, or Fonterra's not talking about a massive future development envelope or things like that, where I think there is a much more legitimate question in terms of transferring future benefits versus future costs and where that sits. I certainly recognise that, you know, this is an inherently rural zone. Practically speaking, subdivision requirements, existing land uses, etc., will to a certain extent, in a practical sense, limit the future development of incompatible or other activities which might cause reverse sensitivity effects on Fonterra. But you know, it becomes a little bit circular because, as I talked about, a single dwelling can have a quite profound effect if it impacts on a wastewater setback or something like that. So we'll go away and reflect on that, but yeah.
It's your submission that, you know, we should default to the minimum regulatory requirements as it applies to Fonterra, but also that should apply to the rural environment as well. If there are alternatives that we should consider, then I think it is incumbent on Fonterra, who have proposed these provisions, to satisfy us that it is the most appropriate outcome.
Yep, no, I appreciate that. So, yeah.
Unless there's anything else you want to say, we'll take our lunch break.
I think that's probably it for this hearing, so thank you.
Thank you very much, and we did appreciate the full breadth of evidence to set you up for future hearings. That's been helpful. Thank you. Look, I think we need at least half an hour. Look, we will take half an hour for lunch. I can see Mr. Karansayu here waiting. Well, thank you.
Tēnā koutou katoa. Thank you for the opportunity to hear from us today. My name is Cedric Karansaya. I'm a counsel for both Primeport Timaru Limited and Timaru District Holdings Limited. Appearing with me today is Kim Seaton, planner, who you'll be hearing from, and we're here to assist you as best as we can and answer your questions. We also have with us today two representatives from Primeport and Timaru District Holdings Limited. We have Phil Melhop here from Primeport and also Fraser Munro for Timaru District Holdings Limited, in case there are some questions about operational issues, or I understand you've been on a site visit recently, so if you have any questions arising from that.
Thank you, that was very helpful. Thank you for facilitating that.
Okay, so I have pre-circulated some legal submissions. I understand they would have been read beforehand, so I won't read them to you, but I just want to perhaps just talk to some main points. So I'll skip through the introduction and the overview, other than just to say that in hearing A, we provided statement of evidence from Fraser Munro, and the content of that evidence remains relevant to this hearing because it does talk about the operational matters of the port zone. Moving on to page 3, I have one paragraph there just talking about the legal framework. That was more fully set out in hearing A legal submissions. Again, I won't repeat that. But I want to just briefly touch on point 4, which is just to re-emphasise that the port is recognised in the higher order planning documents, the New Zealand Coastal Policy Statement and the Regional Policy Statement. And if I could just briefly touch on 4.1 B, C and D. There feel like 3 prongs that I just want to briefly canvass today. So the higher order documents talk about providing for the efficient, safe and efficient development, operation, maintenance and upgrade of the port. And of course, we're here today to talk about the port zone, and the way the port zone has been designed, which is a special purpose port zone, is to take what the operative plan and improve it. The operative plan just had industrial zones, and so the port was an industrial zone. And so what has been done in this proposed plan is to recognise that the port is different, it is special, and so it is a special purpose port zone. And it does better than an industrial zone provide for the development, operation, maintenance, upgrade of the port. So that's, if you like, plank 1. Plank 2, or if you like, paragraph C here, talks about providing for a range of associated activities that have an operational requirement to be located in that environment. Again, this specific purpose port zone being proposed before you, panel, better achieves that than an industrial zone. And lastly, avoiding development that may result in reverse sensitivity effects. If you look at the bespoke provisions of the port zone, that's why it provides for compatible industrial activities, and sensitive activities such as residential, well, preschools, hospitals, whatever the case might be, you'll see it's not provided for in the zone. So if you like, the 3 planks are hit with the notified zone that is before you. Moving on to the next page, at heading number 5, just starting off there's agreement between Ms. Hollier and 3 other planners, Ms. Seaton, also Ms. Trevella for the oil companies, and Ms. Tate for Fonterra, agreeing that the port zone provisions are most appropriate. So I won't labour on that point other than say that all the planners agree it's a sensible outcome, it is most appropriate. I just want to touch on a submission by Property Income Limited. The reason I want to touch on that is because they have lodged a submission that essentially seeks to widen the types of industrial zones that can occur in the port zone. So that's almost the same as just a general industrial zone. Now, the Property Income haven't called evidence to support that, and that not appearing before you. I just want to emphasise that, again, the port zone is meant to be different from a general industrial zone, and the idea is to provide for industrial activities that have an operational need to be there. There's a limited amount of land in the port, and to fill it up with, if you like, just every single type of industry out there is not an efficient use of a scarce resource.
Mr. Karansaya, are they an occupant of the port zone, or it's just an unrelated entity that's made a submission on the port zone? Do you know? Or?
I actually don't know their background. I'm not sure if...
Okay. That's all I need for now.
Yep.
We'll take that up perhaps with 42A. Can give us a little bit more information, but thank you.
Thank you, Mark. Okay, so that's really all I wanted to talk about in point number 5. Point number 6, I just briefly note there that again we have agreement between Ms. Seaton and Ms. Hollier about removing the, which is essentially an error, a height overlay, which shouldn't have applied to the port, and a minor thing, which is just to amend the map layer title from port purpose zone to port zone, just for consistency throughout the plan. Moving on to the definitions, there's again an agreement that the definition of port activity is appropriate. Again, it's just to give effect to the higher order documents. And really the last thing to record is there's still, if you like, not full congruence in the definition of reverse sensitivity, but it is appreciated that there's a lot more to go down the hearing path. You probably want to hear from, in terms of other zones, what reverse sensitivity is about, so it's probably something we come back to towards the end of the process. Really, the last point I just record there as a matter of courtesy really is that one of my clients, Timaru District Holdings Limited, has made submissions on the city centre zone, but we're just not calling any evidence on that and don't intend to appear later in the week to speak to those. I'm happy to answer any questions.
No, I think that's all clear. Thank you very much for that.
Thank you very much.
From Ms. Seaton. Thanks.
Around. Thank you. I have not prepared a separate summary of evidence, largely because there have been no further matters arising from the additional Section 42A, nor from the other evidence that I felt any need to comment on. So I'll just very briefly run through the key points in my executive summary, and they're largely consistent with what Mr. Karansayo has said as well, which is that we've sought the retention of the port zone provisions in their entirety, including the definition of port activity, and including not further loosening the permitted industrial activities per the Property Income Fund request, removal of the height-specific control overlay, and again, thus far my opinion on the reverse sensitivity definition hasn't changed. Happy to answer any questions.
Thank you, Ms. Seaton. I am interested in the definition of reverse sensitivity matter.
Yep.
I note that Ms. Hollier in her summary report, summary section 42A, in her section 42A report, that is, she did go into quite some detail around the definition and the nuances of how the concept of reverse sensitivity applies within Ports Policy 1B. Could you respond to that for me? In the one sense, Clause B, according to Ms. Hollier, is a narrow interpretation limited to the operation of the port, whereas Clause C is a broader application. I'm interested in how your view differs and why you're pursuing that different alternative definition.
In terms of recalling what the Section 42A said on the reverse sensitivity definition and that policy, I don't disagree with what the planner has said about the policy, what Ms. Hollier said about the policy in respect of 1B being quite specific to the port operations, and then 1.3, was it C? Which is more about the broader port rather than just the core port operational area. So I don't disagree with that. The only respect in which Ms. Hollier and I disagree is that I feel that the current definition, where Ms. Hollier references anticipated activities, is too uncertain. That's the only way in which we disagree. Yeah, that's it. It's nothing fundamental in terms of how the reverse sensitivity definition would be interpreted in terms of Policy 1, for example.
that's good. Thank you for clarifying that. I had been mulling over that one.
Thank you.
So there's it's the semantics or one expression of text within.
Correct. It's just different levels of comfort around certainty and the definition.
Okay,
Yes.
thank you. That's very helpful.
Thank you.
Actually, Ms Seaton, I don't have any additional questions for you. I think that's all clear and helpful to see the alignment with the provisions as proposed and your view of it. Mr Caron-Sayre is quite right. The definition of reverse sensitivity is being tested in this process in lots of ways. It's probably quite a good test for it because we actually get think about how it might apply in different zones, and I don't know whether you'd given should it just be one definition that applies to all activities?
That would be my opinion at the moment, based on where we're sitting at the moment. I having said this is where we sit for the time being, a little bit like you, I'm inclined to reserve the ability to change my mind at a later point as we move through these chapters, but presently that's what I think is the appropriate definition, and I don't think there would be a need for differing definitions. I've not struck another situation in another district plan where there's a need for differing definitions, but let's see how we go.
We may have touched on this in hearing A, just test my memory, but I mean the National Planning Standards haven't attempted to come up with a definition. I think there was a suggestion that they might have attempted to and then abandoned it through the process. So just,
I'm not sure whether they would have attempted and abandoned it, but it's a little bit of a tricky one, as you've discovered. So yeah.
No, look, I think that's been very, very helpful.
Thank you.
Thank you, Mr. Caron-Sayre. Mr. Rawlings, if you can come forward to the table, thank you.
Good evening again. Right, what's my bitch about? You got my submission there? Or do I read it out, or what do we do? Can't hear.
And read it out to us if you like, or you can speak to us about it.
Probably read it, I think. Can't remember what I wrote.
Okay.
Right. What gets me is the ability to build additional accommodation on small sites. You know, there's a hell of a lot of 2 hectare blocks out where in the outer suburbs, well not outer suburbs, what we call them out there. I don't know. Anyway, lifestyle blocks, right? People have got very small blocks, some of them. And my neighbour tried a trick on me 12 years ago to build a monstrous house, divide off 700 metres on a 200 hectare block. Then a commissioner here granted him the right to do this, which is totally out of the rules within the district. Anyway, I appealed it and we won. Wasn't allowed to do it, you know. You should actually look at the court's opinion on what actually happened. But the biggest thing really peeved me is I never got grant. It cost me 56 grand to fight this council. and never got granted costs. I could have appealed it, but I got blackmailed into the position, if you appeal that, we'll appeal the whole decision. That was a hell of a risk. So what I would like, number one, is after he won the case, he then tried to build a granny flat for a relative. 400 square metre house for a granny flat, you know, just a try on. And so what I think you're, under your new rules, you're allowing an 80 square metre granny flat in these small blocks. Yeah, there's something going on anyway. Well, that accommodation should be a relocatable thing. So when the person dies, which they usually do within a few years of going into a granny flat, the thing should be gone. The other thing was, the other trick was, the dependent relative was a 20-year-old student. You know? Yes, it might have been a dependent relative upon the owner of the block. But, you know, there's no rules under the condition of doing it, you know, to actually research it properly as to what is really a dependent relative. So, that, you know, had two court cases. What else do I go on about? Yeah, well,
Is your concern about small or additional dwellings in the rural zone or anywhere in the district?
no, rural zone.
Just the rural zone?
Yeah.
Yep, thank you.
And the other thing, that one of my concerns is the rules that apply for buildings out in the rural zone. They're the same as what apply in town. Well, it's ridiculous, you know. People out our way, well, this is another thing that was going to happen to me. He was going to build a 500 square metre shed right on the boundary, and under the rules they could do it. So when neighbours start having feuds, they just apply for a building consent and bang a shed up to get into their neighbours. And if you know, I'm only in a small block of land and you drive round and there's sheds everywhere, you know, it's just ridiculous. Some of them are built right on the roadside. I know there was a deliberate one built in front of one of my neighbours just to block his view. And this is the sort of dirty tricks they do up there. They've all got the money to, you know, I suppose because we live in a lifestyle block, we've got the money to be able to do things, and this is what they do. And I think that, you know, the rules on building sheds on lifestyle blocks should be looked at, just how far they are from existing neighbouring houses. You know.
Mr. Rawlings, what are you asking the panel to do in terms of the rural zone provisions?
Well, the number one is look at the restrictions or lack of restrictions on building within those zones.
So more controls on buildings in terms of the number of houses, the size of the houses,
Well,
or their location on an allotment?
Yeah, well, okay, under the rules you can build a granny flat, right? So that granny flat should be a granny flat size, which I think there is a rule of 80 square metres you've got in, but that thing should be a relocatable thing.
Right.
You know, one of the neighbours built a granny flat on his small block, and there it stayed because it was all concrete foundation, never went. And they turned around and sold it for a fortune.
Right.
So, the rule of granny flats is too loose. And dependent relative is far too loose.
Okay. Right, I think I understand that. I'll just see if the panel have any questions for you on your submission.
Thank you, Mr Rawlings. Just reading your written submission, and I've just heard your exchange with Commissioner Robinson. In terms of the 80 square metres for a granny flat, are you concerned at all with that size area, or is it the fact, so you're just focusing on the fact that you would like it to be relocatable, is that correct?
Mainly relocatable.
Yeah, sure. And do you have any personal aspirations to have one of these on your site at all, or is this a general concern?
I could, but no.
No, so
when I retire from my block, it'll be into town, I suppose.
Right. So it's nothing. You're not seeking this change for your own benefit.
No.
It's more a general concern about the district.
And when I depart that place, I'll be stuck in town.
Okay, thank you. That's helpful. Thanks.
Okay.
Well, thank you for taking the time, Mr Rawlings, for coming in and speaking with us.
No, I was going to have a go at another bit too.
Oh, have you got more to say? We're tracking along with your written submission. Is there another?
Right. Well, okay. In your proposal for alterations to the district plan, there is a lot of discretionary activities. The cost of opposing requests is expensive, and the court costs does not get granted in most of the cases. The Environment Court do not grant the winner of the case any costs.
Well, that's a little bit outside of our remit, but I take your point that discretionary activities can lead to a contested hearing process.
Oh, hell yeah, I can
that
tell you
parties
that,
will likely incur the cost of doing so.
Yes. Well, in my view, the applicant should pay half everyone's costs. Cost this council here a fortune, this goes to mine.
Okay.
And also myself and the applicant. So, this discretionary activity thing should be wiped. So they can't cause the hassle.
Right, okay. So all activities should either be permitted or prohibited, you're saying?
Pardon?
Should all activities then either be permitted or prohibited?
Yeah. Either, you buy out there, if there's the rules, abide by them.
Okay, all right. Well, thank you very much for your submission, Mr Rawlings.
You're welcome. You want to read my court case if you want an education, I tell you. She was a beaut.
Next submitter, I think, is online video link, Enviro NZ.
Good afternoon.
Good afternoon. Ms Rosser, welcome back. And we'll hear from you.
Thank you. Yes, obviously I spoke to the panel previously on hearing A, strategic direction and overarching matters. Can you, there is a slight echo in the response. No, that's better now, thank you. I just want to discuss a couple of submission points. Obviously, Enviro NZ operates collection recycling services in the Timaru district and operates the landfill, the resource recovery facility, transfer stations at Redruth and transfer stations across the district. And therefore there are points of interest in the general industrial zone and the rural zone. If I just go to the rural zone, industrial zone first, the general industrial zone, I just want to confirm Enviro NZ does not wish to proceed with a new precinct for the Redruth area, as was proposed in the submission. that precinct was considered in light of the existing heavy industrial zone, and it was, I think, thought about that as aligning with that. However, given the designation of the landfill and the layout of the landfill, it was not considered appropriate to proceed with that. So that leaves us just to acknowledge a couple of other points. One was in respect of submission point 13, which was regards to the General Industrial Zone Policy 5. I accept Ms. Hollier's drafting approach in terms of to say that you should only allow offensive trades rather than allow offensive trades if, and understand the way that she's drafted that throughout the plan. So that's accepted, and therefore accept the rejection of that submission point. In relation to submission point 14, which was to support policy 6, that we supported it in relation to the fact that other activities in the general industrial zone can give rise to reverse sensitivity effects, which can be quite pervasive with respect to waste management sites and landfills. And I definitely don't support the enablement of supermarkets in the general industrial zone as put forward by the Woolworths submission, and therefore support the recommended version of that policy in the Section 42A report. That just leaves the submission point 15, which queried the gross floor area for convenience stores, restaurants, cafes and takeaway food outlets as a permitted activity in the General Industrial Zone Rule 3. The proposed gross floor area is 200 square metres, and the Section 42A report recommended that this be retained. The proposed relief is actually wasn't mentioned in the submission, but I consider it should be 100 square metres, as I think 200 square metres would have the potential to result in a reasonably large restaurant or cafe, etc. I note that there are quite a few other district plans in New Zealand that have a smaller gross floor area for a similar rule. Auckland Unitary Plan, Light Industrial Zone, dairies are 100 square metres and food and beverage outlets are 120 square metres. The appeals version of the new Plymouth District Plan has a gross floor area of 100 square metres for food and beverage. The Wellington City Plan requires a discretionary activity consent for food and beverage outlets, so not even permitting them in the industrial zone. And Dunedin, it's a gross floor area for restaurants of 50 square metres. So I think there's quite a strong precedent for reducing that 200 square metres. The only one I found over that was Hamilton Plan, which was 250. So, and I guess I would confirm that size just with an example of where a garden cafe is set up next to a transfer station that Environment has in Auckland. And obviously the garden cafe, I suggest, would have, I think it had a reasonable footprint, but it was within a larger retail outlet. I think it's a Mitre 10. Excuse me. And this resulted in a number of complaints and significant compliance costs. Obviously, things have been improved in site to obviously not create any complaints for some time. However, it still may impact the site when air discharge consents are required to be renewed, given the complaint history. So in in that sense, I think just having a smaller pool of basically in terms of a waste management site, a restaurant can be, as it were, a sensitive activity, and therefore having less people, I guess, congregating can certainly help in that regard. Excuse me. So there's just one other point to discuss, which was in relation to the general rural zone. EnviroNZ submitted at submission point 17 that clean fills and managed fills do not have a consenting pathway in the plan, and requested that these types of landfills are discretionary instead of a non-complying activity. Firstly, the point is that the clean fills and managed fills, I think, should be separately considered to class 1 and 2 landfills, which obviously accept producible waste and general waste, and therefore they have a much higher level of effects. So I'm definitely not considering that those are discretionary activities. That's, I guess, in context, obviously there is an existing, the Red Roof facility is existing, and I don't think there's basically room for another landfill in the district for some time of that nature. Oh, excuse me. The lingering cough. And it seems to me that the submission point can be read that clean fills and possibly managed fills should be provided or can be provided with a discretionary activity rule that is specific for these activities, i.e. I think they should have a separate rule, and I think the submission point can be read that way. These clean fills and managed fills, obviously, unless they fill an existing urban quarry or a large development site within the urban areas, can only be located in a general rural zone. They often provide for the reverse process of quarrying, and EnviroNZ have certainly demonstrated that they have their Pokeno facility is basically filling up the wholesome quarry at that location. And they are also, I think, clean fills particularly have a definition in the plan. Managed fills do not, and therefore, I think if managed fills were to be considered in this way, I think they would need a definition to be secure in that. I therefore accept the recommendation that managed fills can be considered as a non-complying activity. But for clean fills, I think this they can be, because they have their own definition in the plan, and they are basically inert substances that do not, I think the definition is quite specific. They a non-compliant activity, I don't think is the correct activity status for them. If the Timaru district experienced sudden growth and urban development, clean fill will be generated in the construction of that development, and it must have somewhere to go. We've seen certainly in other parts of the country that transport projects are particularly prone to generating large amounts of clean fill. If you get any large cuts or tunnelling, they need a clean fill to put that matter in. It's very difficult to have something on hand to dispose of that clean fill otherwise. Saying it is not expected does not avoid an anticipated problem. I think, therefore, a discretionary activity as status will allow for this very possible eventuality. I think if it had a discretionary activity rule for clean fills, it would meet the objectives and policies of the general rural zone. Policy 7 would still apply and all strands of the policy would still need to be met. A discretionary activity would better integrate waste infrastructure with development. It would also align with the regional plan, particularly policy 1933, which promotes an integrated approach to waste management in the region. I.e., you've got to have somewhere to put this clean fill. And it would also align with policy 922, minimising the adverse effects on the environment caused by residual waste, remedied, avoided or mitigated. Excuse me. And on that note, I think I should finish.
Thank you for that. So I was just following along with the written submission that EnviroWaste filed, and just on that issue of the distinction between landfills and clean fills, you had said you were neutral on the provision. You are actually seeking a change to Rule 29. Is that correct? Or
I don't think. No, I think that rule can stay. I think what's being sought is that there is a separate discretionary activity rule for clean fills.
Okay. All right. Thank you for clarifying that. I'll just check whether other commissioners have questions. No further questions for you. Thank you very much for your presentation. And we obviously heard from you in the hearing A as well, so are you intending to return again for any parts of, will you be appearing in relation to designations or?
Yes, designations and infrastructure, okay. No doubt.
Great. Thank you. We'll look forward to your presentation then.
Okay, cheers. Thank you.
Horticulture New Zealand. Thank you. Welcome. So we just note, and reading ahead, that Mr. Hodgson, your planning evidence also relates to the next submitter. So are you intending to effectively have two separate presentations, or can we hear from the corporate or policy advice from your client companies and then just hear from you once and you can economise in terms of your presentation?
My apologies. The issue will be the arrival of Hannah Ritchie from New Zealand Pork. The day didn't plan out as we intended. We were off to a pig farm, but things fell through. So Hannah's travelled down independently. I'm not too sure when she will arrive. So my thinking was that, we could hear from Sarah from Hort New Zealand. You could have some time with me and any planning questions, and then when Hannah arrives, you can hear from her. And if you have any follow-up questions for me, we can deal with those there. Wonderful. Thank you.
I'll keep it on. Cool. Good afternoon. My name is Sarah Cameron. I'm the Senior Policy Analyst for Horticulture New Zealand. So I look after 5 regions in terms of environmental policy, and Canterbury being one of them. I'm going to take all our evidence as read, and I just want to talk a little bit about growth in the area and a little bit about reverse sensitivity and how growers mitigate their effects, if that's okay. So Timaru is a growth area for horticulture. Lots of apple production going on here, as well as potatoes and blackcurrants. So 65% of potatoes grown in New Zealand are grown in Canterbury, and a large part of that, the production is in Timaru. Most, if not all, of blackcurrant production is in Canterbury, with a large part of that being in Timaru, and that is grown for concentrate purposes, so the Ribena, the Barkers that you see in the supermarket. In terms of different crops, growth that are looking to come here, so we've got a grower that is looking to trial kiwi fruit, so the green variety, as well as pears. So very much an area where growers are looking outside the box of what can be grown. There are two main processing companies here, McCain's obviously for the potatoes and the processed veg. I feel like I'm missing something. I can't think what else. So as you will see in our evidence, it generally relates to reverse sensitivity. And I just wanted to talk about how growers themselves kind of mitigate this. So within horticulture, we have two good agricultural practice systems called New Zealand GAP and Global GAP. So if you grow and sell fruit domestically, you have to be registered with New Zealand GAP. And if you sell and grow internationally, you must be registered with Global GAP. So these standards set a range of social practice, labour, health and safety, food safety, environmental practices that growers have to meet before they can sell their fruit. And one of the standards is that they must adhere to regional district plan rules. So when it comes to mitigating reverse sensitivity, for an example, agrochemical spraying, there's specific rules and standards in GAP that requires that they must, to the best of their ability, mitigate the effects on neighbours. And they do this by target spraying. The nozzles that they use is very targeted, so the spray drift is quite minimal. Planting shelter belts. Shelter belts are a really good way to mitigate spray drift from neighbours. That's just one example of how they try and mitigate reverse sensitivity, bearing in mind that, they do grow in rural environments, that rural type activities do take place and that they do have effects. So it's probably enough from me. I will pass over to Vance and he can talk about his evidence. Thank you.
Thanks, Sarah. Yes, my evidence, again, we'll just take that as read, and the focus there really was, again, on reverse sensitivity and the applicability of the sensitive activity standard GRUS S4 and whether that could be applied to those listed sensitive activities of residential visitor accommodation and residential care activities and educational activities. And my recommendation around that was that, in my opinion, it would be appropriate to apply that setback. These are, defined sensitive activities, and there is a really useful permitted activity threshold that's been introduced into those rules, based around the number of kids, for example, in the educational facility, the number of visitors at 6 in a visitor accommodation scenario. Very useful standards, but from the perspective of reverse sensitivity and conflict, still introducing activity into an environment where, despite all the best efforts of internalising effects, there are related effects to primary production activities that can conflict with the values and the amenity expected by some of those other activities. That mechanism of separation, while it's a very blunt tool, as we know setbacks always are, it provides the ability to separate the activities and provide a resource consent pathway to test whether a non-compliance might be appropriate and what conditions might be put around an activity. The other area of my evidence covered shelter bouts, which were an issue for Horticulture New Zealand, and the recommendation there that the recommended 30-metre setback of new shelter bouts and woodlots from residential units from an amenity and a fire risk perspective be a reciprocal 30-metre setback to also apply to new residential units from those existing shelter bouts. And the other area of my evidence covered off artificial crop protection structures. And hopefully, helpfully for the commissioners, I've provided through Sarah a copy of that consent order from Waikato, which was quite a recent settlement around those activities. Artificial crop protection structures, I'm sure you're familiar with the environment, and obviously we see them with MA apples as a good example around Timaru Airport. And the use of those structures, which are generally in that 5 to 6 metre height regime, with a particular colour treatment that's applied to the sides of those structures, which is typically a darker colour, a green or a black, which is more sensitive, and a white on top, which white assisting, as I understand it, Sarah will be able to expand on this, assists with sunlight essentially getting through to the trees underneath in the orchard. And I'd express support in my evidence for the permanent and seasonal worker accommodation package that the plan in the Section 42A has recommended.
I'll just see if there's any questions.
Thank you. So reading through your evidence in chief and having looked through the Section 42A report, I see that there's two options that you could potentially work with in relation to the reverse sensitivity and the GRUS. So you've said that either you could apply GRUS Standard 4 to Rules 7 through 9, or seek restricted discretionary status. And what I'm interested in is what is your preference there? Am I correct that your preference is that you'd apply the standard to those GRUS rules, or is it 6 of one, half a dozen of the other, or is there any unintended kind of consequences on either of those options that you'd like to highlight for us?
No, not really. Those activities to be have a place in the rural environment, but there's a threshold there where conflict, I guess, is probably inevitable. And this is a district that has seen, a really seen growth in countryside living, I suppose. It's become a very attractive place to have a small block. It's the climate's changed, the landscape's lovely, and there's a lot going on out there. And it's also a place where we know there's some significant growth for primary production activity, and particularly in horticulture. So there's some real opportunities there with both assisting with provisioning domestic food supply, but exports as well, which is really exciting. If I had to pick a preference, it would probably lean towards the application of setbacks. To me, they're an effective tool. They are very blunt. They still provide that mechanism for resource consent and testing. It's an efficient way of dealing with the problem.
Ms Cameron, I enjoyed reading the stuff about the REC.
Yeah.
I really enjoyed that. Just picking up on that matter, paragraph 16, you talk about Pacific Island workers return to their home to start horticultural businesses. Would you know how many workers have taken skills learnt here back home to use them there and to even perhaps start a business?
Sorry, I couldn't quite hear. Sorry. Paragraph 16.
Paragraph 16, you talk about Pacific Island workers returning to their home to start a horticultural business. This is what you're hoping, this is what the scheme's, part of what the scheme's about.
Yes.
Would you know how many workers from the Pacific Islands have taken skills learnt here back home to use them there and to even perhaps start a business?
No, I don't have that data, but I can ask the scheme if they have recorded that data and provide that to you.
Thank you, that would be really helpful.
Just make a note of that. Must be
I don't have any more questions. Thank you.
Just a question for Mr Hodgson, just in relation to the setbacks, and you're suggesting that they should apply to activities such as schools. So the rule at the moment, I'm just trying to understand how that would apply to an education activity. We're not just talking about buildings, presumably, we're also talking about playgrounds or sports fields and the like. Would they be allowed for in the setback, or should there effectively be a buffer strip planted or some other physical means to keep children out of the buffer? How would that work?
Yeah, I think you would have to take it probably from the property boundary, which would account for any of those other sort of ancillary activities. The conflict can be with the building and the activities that are internal there, but yes, certainly playgrounds and outdoor areas. I can think of a situation, Pukekohe is a classic example with a school that's been erected adjacent to a commercial veggie growing operation, and the kids out the playground, smelling the onion skins that are getting burnt in the burners or the spray drift, and it's conflict that can potentially be avoided or certainly put through a consent process to work out what the best solutions are.
I think over the years I've been involved in a couple of school resource consenting matters adjacent to horticulture and agricultural activities, and in a resource consent scenario, the solution at the time at least was that those areas should be planted. And is that necessary in your view? I mean, what happens to those 20-metre strips?
That's right. I mean, and it relates to the effect, doesn't it, in terms of what that planting might achieve. There's visual mitigation that might be achieved. I understand it can be effective in dealing with spray drift in some circumstances. Noise, not so much. You need a very deep planted area to have any effect on noise attenuation and amenity, really.
What about shelter belts as a mitigation measure? Should that be something that is a specific solution in relation to those sorts of activities, not, where there is an element of an outdoor use or activity in conjunction with any building?
Absolutely, and there might be a win-win with both activities in that circumstance. Yeah.
Have you seen that in a rule drafting sense in a district plan, or?
Not that I can think of offhand, no. I could have a look if that would assist the panel.
Yeah, it would be useful just to understand whether there are examples of that. And just as an aside, not specifically related to your submission at all, but we heard evidence or a submission from Ms. Di Lucas yesterday, a landscape architect, who has a preference for, or at least wishes to encourage the use of Indigenous planting in the context of shelter belts. I just wondered whether you or your client had a view on whether that's a practical solution to planting for shelter belts. Is that something that is accommodated in the horticultural industry?
Generally, they are particular types. I would have to take some advice on that. Okay. I think whatever is effective, but let me come back to you.
Yep. That would be of interest, so thank you. Right, Mr Hodgson, shall we segue into the New Zealand pork industry board submission?
Hannah's not here.
Because we could just take a short break if you want.
Okay, and I'll call
I'd rather,
Hannah.
I think you should probably wait for your client, so. Yeah, that's right. Okay. Look, we'll just take a 10-minute break now, and Hannah's here. There we are.
Thank you. I'm going to go.
My bag's in your car.
Look, welcome, Miss Ritchie. Do you need a few minutes just to collect yourself? Have you just...
Can I just confer with Mr Hodgson?
You may absolutely do that.
Oh, yeah.
Okay.
Thank you.
And duck out. That'll be fine.
you.
Thank you, Commissioners. Yes, as we discussed, I've sort of covered off the planning-related issues, and there's a crossover with the issues of interest to New Zealand Pork and Horticulture New Zealand. So I'll now pass on to Hannah to give the industry evidence for New Zealand Pork.
Thank you. I'm not going to go into too much detail, and obviously I'll take my evidence as read, but I really just wanted to just provide a bit of context for why New Zealand Pork is so interested in the Timaru District Plan. So the pork industry is small in New Zealand. There's about 80 commercial pig farms, and 3 of those are in the Timaru District. So, you know, we certainly don't have the significance of some of the other primary sector groups of relevance to the district. But while the numbers aren't big at the moment, I think the Timaru District has the potential for a lot of potential growth in the pork industry in the future. There's a few reasons why. One is the proximity to the fresh pork processing plant out in Caroline Bay. The climate and the soil conditions in Timaru are very favourable, particularly for outdoor pig farming, which is pretty much limited to the Canterbury region in New Zealand. And it's good transport links, and it's close to lots of arable farming areas, so particularly for outdoor pig farms, access to grain crops and straw bedding. So there's a lot of favourable conditions there which would make Timaru a potential option for people looking to open pig farms in the future. And while the industry is small, there are some environmental benefits to pig farming over other types of livestock farming, which we think may increase the potential for diversification into pig farming systems in the future. So, for instance, more manageable nutrient discharges, because pigs, for the most part, are kept indoors. Even on an outdoor system, it's only the sows and their young that are typically on pasture, and the rest of the herd will be indoors in various different types of systems. So less sort of diffuse nutrient losses to water, much lower greenhouse gas emissions. So pigs are monogastric animals, so they produce far fewer greenhouse gas emissions than other ruminant livestock. And smaller land use requirements, smaller footprints needed to produce the animals. And all of these issues, they're becoming increasingly important for regulators, but also for consumers. And we think that, you know, with conversations around land use diversification, we see pork as having some good potential. So our interest in the new district plan isn't necessarily for the farms that exist at the moment, it's for the potential of the industry and how the district can play a part in that. So we did, along with the other primary sector groups, NZ Pork was involved in some discussions during the proposed plan drafting. So I'm sure, as Vance has probably, Mr Hodgson has probably outlined already, NZ Pork was largely supportive of the planning framework that's been put together for pig farming. So in particular, we support the way that the plan has differentiated between what we refer to as intensive and extensive pig farming systems. Essentially because the effects to be managed from the 2 different types of systems are very different. So we consider extensive farming to be pigs on pasture, basically. So it's what we call a free-farmed system where a sow and her young are outdoors and quite low stocking rates, lots of grass cover. And this, essentially, the type of effects from that would be similar to any other type of pastoral farming system with relatively low stocking rates. Intensive systems are those that are either indoor-based or outdoors, but at a stocking rate that would preclude the maintenance of ground cover. So we would expect a higher level of environmental effects from those types of systems. So we think it's appropriate that they're differentiated between in the plan. And in my experience with NZ Pork, the main resource management issue that we've come across at a district planning level, time and time again, is amenity effects relating to odour. That seems to be the number one issue that farmers come up against fairly regularly. And sources of odour from intensive farming systems, we wouldn't expect too much from extensive systems, but from intensive systems, the sources of odour and the mitigations that farmers can apply to manage those, they're quite well known, they're quite well established. And in my evidence statement, there is a table in there that sort of details some of the common sources and mitigations available. And The planning framework in the proposed plan, and I'm sure hopefully as Mr Hodgson has alluded to, sort of mirrors the planning framework that's come out of other district plans in the Canterbury region around this. We think that those types of issues can be mitigated appropriately through those permitted activity standards that have been proposed. One of the most important things for us as an industry is being able to manage the issue of reverse sensitivity. I do think, in my opinion, it's the biggest environmental issue that the pork industry faces. And we support the use of setbacks in district plan as a tool to be able to manage this issue, because sometimes, despite a pig farmer's best efforts to mitigate odour through their farm systems as much as possible, people nearby will still complain. And, you know, odour, it's very contentious and it's a very individual experience. And what we found in several recent examples that I gave in my evidence is that we've had farmers in situations where they're receiving hundreds of complaints from usually someone that's new to the area, moved in nearby. And in those situations, more often than not, the regional council doesn't find any fault with the farmer. They investigate and they say, look, it's not a problem. But the complaints persist, and that becomes really stressful for the farmer, and I can imagine it becomes really stressful for the complainant too. And no one wants to find themselves in that situation. So we see setbacks as a means of sort of putting a bit of sort of mandatory distance between the pig farm and between residences to try and mitigate those types of effects, because we understand that pig farms can produce odour. You know, they probably can be quite difficult to live around, and that just allows that buffer to allow those odour sources to disperse a little bit and just create that little bit more of a barrier to give the pig farm some more security. So that's something that we're really in favour of in the district plan. And yeah, just overall, like I said, we're in favour of the proposed approach that's been taken. And really, I just wanted to give evidence today just to explain a little bit the context behind that, and hopefully Mr Hodgson's covered off the specifics. Yeah, and I'm happy to take any questions.
Ms Ritchie, just to ask a few questions of you first. Just in terms of reverse sensitivity and just from an industry perspective, so you're coming to this process to say that there are only, you know, a few pig farms in the district currently, so you're looking for a planning framework that's forward-looking. But then we have this concept of reverse sensitivity, so I'm not quite following. If you have a new pig farmer established within the district, how are we supposed to anticipate where the rule might apply? Effectively, you would be coming to an area, so there might already be existing residents.
Yep.
So how can you restrict their activities? They're the first in existing use, and you're bringing a pig farm to a location and then expecting the neighbours to fall in line to that activity. I don't quite understand.
We have in the past, we support the sort of the reciprocity around setbacks. So what I would expect is if a new pig farm is looking to establish, that there's a framework within the district plan that stops that pig farm from setting up too close to someone.
Right, so it would apply to them. So
it goes both ways. We're not saying pig farming is, you know, we're going to put a pig farm here and everyone else has to fall in line. It's essentially, it's to protect the pig farm from setting up in an unsuitable location. So those setbacks should be applied. If a new pig farm is looking to establish, they shouldn't be able to do that within.
So it's not
that setback distance.
It's not really the traditional reverse sensitivity. It's actually ensuring that the zone provisions provide for the separation in the first instance so that the issue doesn't arise.
Yeah, and I guess reverse sensitivity, it's a term I use frequently to talk about the opposite effect when neighbours move in, but just as equally it applies to protecting residents from inappropriately located pig farming activities, because we don't want to see that in the industry either.
Yeah. So really you're just relying on sound resource management planning to ensure that incompatible land uses are kept apart.
Hopefully, yes. Yes. Setting up a pig farm is a very expensive business, and we would hate to see a farmer do that in the wrong location. Yes.
Okay, I understand that. Do you have any questions for Ms Ritchie?
Yes, I do. Talking about sensitive activities, I refer to your paragraph 61, where you say even if complaints about such odours are not substantiated, they can still create pressure that threatens the continued operation of these farms.
Yeah.
Now, I don't doubt what you're saying, but I'd like to understand a bit more about the nature of that pressure. We hear it, but we don't...
Yeah, absolutely. To use one of the examples that's in my evidence statement, this is a farm I've been working with quite closely on this. They've been in their neighbourhood for, the farm's been operating since the 80s, unchanged since the 1990s, but the level of complaints escalated when a new neighbour moved in. So there's been no change in the activity, it's just a change in how someone's perceiving that activity. And that farmer dealt with hundreds of complaints to the council. The complainant didn't want to engage directly with the farmer, just wanted to do it all via the regional council and the district council. The farmer then gets a lot of increased scrutiny from the council, so increased cost of compliance for one. He was having to pay every time a compliance officer came out and would do an assessment of his farm. But also the incidences where this can happen, it can corrode the farmer's feeling of place in his community, the ongoing viability of his business. So this farm, it's in between Rolleston and West Melton, just outside of Christchurch. I don't know if you know the area, but it's hugely popular with lifestylers basically, and there's been a boom in that. And he now thinks from what's happened and from the personal stress that this has taken on him, that his farm just isn't viable anymore in that location. Wow. And it's not entirely to do with these complaints, it's to do with how the district plan has how that area has changed over time. But, it affected his sense of place in his community. I think that he's always had this really good relationship with his neighbours, and then all of a sudden he sort of felt like he was under personal attack almost. And even just observing his body language when I was out on visits with him and the regional council, he physically looked like he was ready to tear his hair out. Such was the level of personal stress that this was causing, because odour complaints are really difficult because it's a pig farm. Pig farms smell, there is a level of odour there, and that's why we support district plan provisions that recognise that the rural environment is a productive working rural environment, and there is an element sometimes of odour that goes along with that. And it's very difficult for a farmer to completely internalise those effects. It would be impossible for a farmer, any farm system, to do that. But it's almost like this is what these complainants expect, that this woman was complaining every time she smelt the pig farm. And that becomes an impossibility for that farmer to deal with. It becomes an impossible situation where they can't fix that problem, and yet the council is constantly telling them, oh, this person's complained again, but there is no way for the farmer to fix that, and that becomes a really stressful experience. And as I said, I can imagine it's stressful for the person complaining too.
Yeah.
Because they're in a situation where they're not tolerating their environment, and it's probably causing them a certain amount of stress and anxiety as well. So, it becomes very personal, and that's not the only example of the way it causes stress to farmers. Yeah.
I thank you. That's been helpful. That leads me to paragraph 64, where you talk about the last sentence, actually. The farmer spends significant time and money on odour mitigation practices and technologies which reduce the odour complaints, but the complaints only ceased when the farmer was able to demonstrate to the regional council that the neighbour had a no complaint covenant registered on their property.
Yes.
So do no complaint covenants work?
Some farmers say they do. I know I've had farms that have had no complaints covenants from neighbours that have complained to the regional council, and the farmer has shown their compliance officer at the council there's no complaints covenant, and the council officer's gone back to the neighbour and said, I've seen your no complaints covenant, you can't complain to us anymore. So some farmers think they work, and most farmers I've spoken to that have allowed land to be subdivided around their farm have them on the titles. But there was this one instance where it wasn't working because the complainant wasn't known to the farm, and unless they know who's complaining, they can't technically it's not. As I understand it, I don't have a lot of experience in this area. This was just from one particular incident. It's not the council, it's not the regional council's job or responsibility to enforce a no complaints covenant. So they ended up having to do this on their own. But to do that, they needed to know who the complainant was. So unless you know who the complainant is, they're not really going to help. And it probably depends on the attitude of the regional council compliance officer as to whether or not they're going to take that as a cut-off for being able to complain or not. So most farmers will have them, and most farmers probably wouldn't want to be without them if they're going to subdivide land. But when it came to crunch, I don't know how useful they would actually be without a farmer having to enforce it themselves through a court process.
No, that's been really helpful. Thank you.
I don't have a particular question. I just wanted to acknowledge your submission, and I learnt so much about pig farming actually, and all the pictures sort of sold it as well. So I just wanted to acknowledge an excellent submission by both of you, and I thought it was very good reading, and great education too on discussions around, I can say, my kitchen table with my children around, did you know that pig farming this and this? So, and it was great to have some live examples in there too. So I really do appreciate selling, painting a picture. So yeah, thank you very much.
Thank you. Ms Ritchie, in your evidence, you've got some images in there of little piglets and examples of outdoor housing. And I understand that what you're seeking is an exemption from the GRUS R100 metre setback for mobile shelters. So my question is, there's an image number 6 shows a movable farrowing hut. So that's the type of movable shelter that you're wanting to be exempt, like that scale around the 10 metres squared, less than 2 metres in height. Is that correct?
Yes.
Yes.
I agree. This one, number 6.
Oh, yes,
that's the
yes.
farrowing hut. Yes.
Yeah. So there's obviously other examples of mobile housing or shelter.
So a farrowing hut is for an individual pig and her litter. There are other types of shelters which are bigger, which would be sort of group housing for sows that don't have litters.
Right.
So they can be in a group, and the shelter will typically just be that, a shelter, somewhere for them to keep dry, keep warm. The farrowing huts are
Those larger shelters you're not seeking exemption for? Just those smaller ones like that in that photo?
Huts, yeah, because the larger group shelters, there'll be far fewer of them.
Yes.
A farrowing hut, there'll be quite a lot of them in a paddock, and
Yes,
having
of
that
course.
100-metre buffer they have to maintain a distance for health reasons and biosecurity reasons, and
Yes.
just because they want their babies away from another mama and her babies, so they need to be quite dispersed within a paddock, and a 100-metre buffer potentially reduces
Constrains
that area
that.
quite a lot. Yeah,
Yeah.
and it's fairly unobtrusive, a farrowing hut. They're quite small, low to the
Yes.
ground.
They're quite low.
Yes.
Yes.
Yeah.
Yeah. Okay. Oh, that's super helpful. Thank you.
To you. At paragraph 40, if I'm referring to your paragraph 40, if a piggery is not reliant on the soils to be fertile for fertility, should it be even located on highly productive land?
That is a very good question. And it is one that MFE and MPI and hopefully the government are making a decision on at the moment. We don't agree with the definition of highly productive land excluding pigs, because while technically they do have feed imported to the site, pig farmers are reliant on the soil resource of the land for a number of other reasons. And that court interpretation specifically related to feed, but there's issues around nutrient assimilation, growing feed elsewhere on the site to feed the pigs, all these sorts of things. It is a very, very good question, and one that I don't have an answer for at the moment, but we're seeking some changes to the National Policy Statement for Highly Productive Land that would acknowledge that that there are reasons for a pig farm to need to be on highly productive land. Yeah.
Okay, thank you.
No, there's nothing I need to repeat, Commissioners. I think we've covered things pretty well.
I'll see if there's any questions for you. No questions? No questions for you? No, and I don't have any questions too. Thank you. It's been a very helpful presentation.
Thank you,
Thank
Commissioners.
you.
Can I just thank Andrew for a really well-written Section 42A report as well. It was an easy read and thorough. Thank you.
Thank you. Federated Farmers. Great. Have we got these people today? No. We have. It's got the original submission. Oh, okay. We'll hear from them. We'll take a tea break after this. Yeah, I don't know. Oh. Yes, I think we will. And then the last submit of the day, are they attending? Or? Yes, they're out. Okay. Well, what we'll do is we'll hear from Ms Johnston and then we'll just take a short break and then we'll come back and hear from them. Thank you.
Good afternoon. My name is Angela Johnston and I am a Senior Policy Advisor for Federated Farmers. I appreciate you would have read our submission and further submissions, so I just want to touch on some fundamental points that we have. Most of Timaru District's land is zoned rural, and while it is important for these areas to keep looking and feeling rural and for productive land to be kept available for food and fibre production, there is also a need to provide landowners with the ability to be innovative, adaptive and flexible as to how they use their land. It must be remembered that the general rural zone is a working business zone and the only space where primary production can occur. The functional and operational needs of food and fibre production need to remain not only protected, but enabled and encouraged. We seek a planning framework that acknowledges that there is a strong responsibility on landowners to manage any effects of their activities on the environment, while at the same time not seeking to burden the district with unnecessary compliance and/or without council trying to impose or implement plans that manage or regulate farming or land use activities themselves, rather than managing the potential effects of those activities. I was part of the stakeholder group that worked with council and other primary industry stakeholders that provided input into the drafting of these provisions prior to notification. It is encouraging that this effort has been largely well received and few major changes sought. Overall, we support the Section 42A recommendations for the amendment of the objectives, policies and rules, as the intent of these provisions has not changed. Thank you.
Thank you. Most of my questions were around your specific submission points, which I understand have largely been addressed now.
Yes.
So I'm not sure whether there's any benefit in running through those, but just to confirm, there's a large table attached to the submission,
yes.
And you're reasonably comfortable that those submission points have been attended to?
Yes.
Yes. There's nothing outstanding that you want to talk through, tease out? Okay.
Not at this stage, no.
Okay.
Probably in further hearings once we get into the other specific areas, but for this chapter itself, no.
Okay, oh good. Oh well, thank you for your time today. I have no further questions.
Have got a question, sorry. It's just a general question. What measures could farmers have in place before they choose to subdivide their land so that down the track reverse sensitive effects can be avoided?
I wasn't expecting that question for this hearing. Sorry, nothing is coming to my mind on that just at this point.
You might need time to have a think, and I'm
Yes.
happy to we're happy to receive a late reply.
Yeah, thank you. That might be best on that one.
Yeah, thank you.
Just on that, it would actually be very interesting to hear what your organisation might say about that, because we're hearing a lot of evidence throughout these hearings about the challenges that are faced in terms of keeping potentially incompatible activities apart from each other.
Yes.
And often the changing land use in the rural environment as land is subdivided to enable more residential activity kind of exacerbates these issues or unpicks what might have been a planning decision in the past that would have kept these activities separate.
Yeah.
So, yeah, I support the fact that I think that's a very interesting question and would appreciate a response. If you can
Absolutely,
provide it.
yes.
Thank you. Look, are there any other questions off the back of that? No. So thank you very much for coming along today.
Thank you.
We're just going to take just a 5-minute break and stretch our legs, and then we'll hear from Ms O'Brien, is that?
Yes, it is. Thank you.
Welcome. Ms O'Brien, just before you get underway, just to help us navigate, there's a number of submissions that have been made in the name of Millwood Finlay Lob Limited.
Yes.
And we're just not clear whether, because we heard from a representative of that company in Hearing Stream A, which was basically just a submission on from the consultancy business rather than a submission on behalf of a client as such. So it was more of a kind of an industry perspective. So can you just help us navigate who you're here for and who the submitter is and the relief that's being sought on behalf of that submitter as opposed to the company, the consultancy company?
Yes. So we're here today relating to Millwood's submission, particularly submission points 60.47 and 60.48. And we have Quarry Hills Development Limited, the director, Mr. Chris McKnight, and Melissa McMullen, who works at Millwood's as a planner with us today.
Right. So is the submission Millwood Finlay Lob's submission, or is the submission Mr. McKnight's submission?
I will pass this to Melissa to answer if that's okay.
So yes, we made a submission on behalf of Mr. McKnight through the Millwood Finlay Lob submission, and then there are other matters which are not distinctly related to a submitter that we're going to be speaking on tomorrow. I'll be back tomorrow to speak on, which are separate from this provision. Just a matter of us not, at the time when we were doing getting all the submissions in at the in a bit of a rush, we just didn't quite separate them out properly. So this is the only one that Millwoods has presented on behalf of a client, and everyone else, all the rest of our clients are specifically under their name, and we are submitting with them.
Okay. So, but the submission presumably was with the authority of Mr. McKnight, and he can confirm that. But it was made in the company's name and the consultancy company's name, not the individual name. Okay. Thank you. I'll hand back to you, Ms. O'Brien. Thank you.
Thank you. Good afternoon, Commissioners. My name is Lucy O'Brien. I am a solicitor at Gresson Dorman & Co, and I am here on behalf of Georgina Hamilton, who is legal counsel for Millwood Finlay Lob.
Thank you.
I have with me Melissa McMullen, who, as I stated, is a planner at Millwood Finlay Lob, and Chris McKnight, the Director of Quarry Hills Development Limited and the developer of the Brookfield Road subdivision. I would like to apologise to the Commissioners for Ms Hamilton's absence today. And
no need, you just carry on, that's fine, thank you.
Thank you. In Ms Hamilton's absence, I will present a short summary of the outstanding issues relating to Millwood's submissions and then introduce Millwood's witnesses, Ms McMullen and Ms McKnight.
Thank you.
Due to the circumstances, I politely request that if there are any questions from the panel relating to legal matters, that I am given the opportunity to confer with Ms Hamilton and provide a written response, please.
That's accepted. Thank you very much for
Thank
being
you.
here.
I would firstly like to clarify one error in Ms Hamilton's legal submissions. At paragraph 1.2, subparagraph A, she references RLZ Standard 2, and this should be RLZ Standard 3. I also confirm that Millwoods would no longer wish to pursue submission point 60.48 relating to RLZ Standard 8. The issues that remain unresolved in relation to Millwood's submission are in regard to submission point 60.47. This relates to RLZ Standard 3, the building coverage standard and the rural lifestyle zone for Brookfield Road specific control area. The key issues are that RLZ S3 is more restrictive than the operative plan's standard for building footprint area for residential dwellings and accessory buildings in the Brookfield specific control area. RLZ S3 does not reflect the increase in the building footprint for residential dwellings in the Brookfield specific control area authorised by the global land use consent referred to in and which accompanied Ms Hamilton's legal submissions.
and no analysis has been provided in the Section 32 report for the rural lifestyle zones of the rationale for a more stringent building coverage requirement for the Brookfield specific control area in the proposed district plan. A further consideration is the feedback received from potential purchasers of lots in the Brookfield subdivision, with a particular focus on the permissible area for garaging. Mr. McKnight addresses this in his evidence and will clarify today the characteristics of some of the lots in the subdivision and the rationale for the requested increase in building coverage to 12.5% for the Brookfield specific control area. Ms. McMillan has completed some further analysis of the restrictions imposed on building areas for the lots in the subdivision, which provides further context to the submission point and the misalignment between the operative plan and proposed plan building coverage standards for the Brookfield specific control area. The former being limited to location within an identified building area on each lot, and the latter being on the basis of a percentage of site area. It is submitted that there is a robust planning basis for the change to the building coverage standard for the Brookfield specific control area, particularly in the absence of any analysis that demonstrates the need for the rural lifestyle zone-wide building coverage standard to apply in the Brookfield specific control area. As already alluded to, Millwards calls Mr. McKnight and Ms. McMillan in support of its submission point. Both witnesses will provide some clarification on matters discussed in the evidence as filed and to take questions from the panel. I would now like to pass over to Ms. McMillan.
I'd just like to start off by presenting the panel with some plans that I will speak to in my notes here. So is it all right if I come forward? Sorry, we only printed 3. So there's 3 of that one and 3 of that one. Okay. But just feel free to spread out. Yeah, thank you. So in front of you, you have the outline development plan, which was produced as part of Plan Change 20, and then a sale plan, which reflects the allotments that were created following subdivision, and you'll see there's some building areas and building setbacks already identified on there, particularly with the larger allotments is what I'd like to draw your attention to at the start. As a starting point, I'd like to clarify that my comments and my evidence are primarily focused on the 5,000 square metre allotments, and that I accept my expert evidence has not considered the proposed change in relation to the 4 larger allotments in any detail. My comment at paragraph 4.6, that 10.6% site coverage, when taking into account the ODP and global consent, is at least the percentage of the site, is incorrect. 10.6% represents the maximum building coverage of 5,000 square metres, when taking into account the 450 square metres and 80 square metres currently allowed between a building and a shed. 10.6% will not be the percentage of site coverage that will apply across all sites, as there is variance between the allotment sizes. However, the difference in coverage will be minimal across the sites when considering how much building coverage is currently permitted and this is still expected to be more than 10%. This also does not change the original position that 12.5% building coverage would be appropriate for the Brookfield Road specific control area. At this point, I'd like to clarify the role of the outline development plan. This restricts building platforms on the larger allotments. The limitations are shown quite specifically on the sale plan, and Mr. McKnight is also happy to limit the building coverage to 700 square metres. The main cause of concern came from Mr. McKnight's experience marketing the smaller 5,000 square metre allotments, and I appreciate there may be significant concern allowing 12.5% building coverage on the larger allotments. I agree it would be inappropriate to allow building footprints of up to 12.5% on these allotments, and therefore it is appropriate to apply a proposed restriction on the building footprint of 12.5% of the site up to a maximum of 700 square metres. To date, we have not provided specific wording of that potential rule, but we're happy to provide that after, if that would be helpful to the panel. I'd also like to clarify some comments that were made within paragraph 4.4 of my evidence. This refers to the site coverage of 350 square metres with 3,000 square metre site as being 11.7%. This was to demonstrate the site coverage that could have existed on the site if Plan Change 20 had progressed as it was initially intended. The numbers shown in the table within the legal evidence from Ms Hamilton at paragraph 2.5 show the percentages as they relate to the allotment sizes that came to be following the conclusion of Plan Change 20. These numbers, when considered with the evidence of Mr McKnight, show that it would be most appropriate to allow for a 12.5% site coverage and are particularly helpful in smoothing out any confusion that might exist between the global land use consent, prospective and existing landowners' understanding of the operative district plan rules and how this all relates to the proposed district plan rules. Alignment is required between the different mechanisms and the currently proposed rules do not provide that. There was little reference made to the outline development plan or existing provisions as they relate to the zone within the Section 32 report, and so as a consequence, it has not flowed through into the provisions that are in the proposed district plan. While the request is now being made over and above what is currently consented and allowed for, at the time of the Plan Change 20 process, there was no ability to test the provisions against the market due to the limited lifestyle zoning available within the district. Mr McKnight has now tested that market and the feedback received supports larger building footprints. The global consent raised no issues with the increased building coverage, especially in regards to it being, it agreed that it was not inconsistent with the objectives and policies of the operative district plan. And I do not believe the increased building coverage as proposed by Millwood Finlay Lob will create any further non-compliance with the objectives and policies of either the operative or the proposed district plan. I'm happy to answer any questions you may have.
Thank you.
I'll just check. Commissioner Day, please.
Thank you, Ms McMillan. I was wondering whether you might be able to take us through some of the points that you've been talking to in relation to the map that we've got up. I think it would just be helpful to kind of contextualise your submission points and just give us that flavour of what you're seeking for your client. Yeah.
Sorry, I'm a bit blind from a middle distance.
Did you want to go?
Can I go closer?
Yes, absolutely.
Okay, cool.
This one.
Oh, I can take it. Fancy. Sorry. Okay. Is there anything in particular you want me to speak to? Is this painful? Oh, up here? Up here? Okay.
What the problem is, how you see it.
Okay. So this section here was subdivided off from the remaining section, which is 60 Landsborough Road here. So it went through a plan change process, which was very involved and did take a number of years and a lot of commitment from Mr McKnight to get over the line. So what is currently operative in the plan is there are specific setbacks. There are specific, so there's setbacks and then there's the additional setbacks in the outline development plan. So setbacks in the operative plan of 10 metres, and then you've got 15 metres from memory up the top here, a significant swathe down here which is non-building, a non-buildable area, and then the original plan change allows for 35 allotments. We ended up, the subdivision ended up having 30 allotments that were created. That was primarily driven by the topography of the site and just what was practical and how it all worked. It is fully serviced by council infrastructure, and it also as part of the plan change process there was significant landscaping and like Boffin Miskell reports and also significant discussion with landowners around the site to get to where it landed with Plan Change 20's decision. in terms of, so we went from, at the moment, in the operative plan, you're allowed a 350 square metre dwelling, including garaging, plus an 80 square metre shed. The global land use consent that was applied for by the applicant because it became apparent that it really wasn't fit for purpose at 350 square metres. The 80 square metres wasn't addressed at that time, primarily due to, again, it just hadn't been tested across the market. And it is important to note that that 350 applies across this entire site, regardless of how big your site is. And then you come to the global land use consent, which was applied for some years ago, but at that point the subdivision did not have title, but it was just one of those things that Mr. McKnight, as a developer, decided it would be more fit for purpose for him to get that global consent than to ask each landowner to do something individually, just based on what he'd heard. So that is what triggered that process. It was a global land use consent that was sought, only for the building footprint for the dwelling. My understanding of that process is that there wasn't any additional expert reporting required for that. And same with I should just revert back to the original plan change with the 350 square metres. There was no actual expert reporting that actually led to that. It was just one of those sort of processes with the plan change that, you're sort of toing and froing in terms of what you're going for and what you're going to put to one side. So that was sort of a negotiation that got to that point. And so now title was issued for the subdivision earlier this year. Yeah, earlier this year. And so the sections have been on the market. Very few sections have sold, and Mr. McKnight's experience has been a lot of people see the 80 square metres, which is the restriction in the operative plan, that is just very unpalatable. And so what we've also got happening across the site is a range of different topographies. So because that building footprint is for 80 square metres, technically if you have slope, let me just orientate myself. So it does slope away sort of along this side. Yeah, and also down more on the side as well. And Mr. McKnight can speak to that a lot better because it is his land, so I will leave that for him if that's okay. So when you've got that slope, it does provide that ability for someone to essentially build into the slope. So that means that, yes, for some people, this won't be a problem at all. They'll be able to get the garaging they want. Perfect. And also the house size they want, as long as it's 450. But for others, particularly these ones up here, it's very flat up here. They just don't have that ability. And it's been a real sticking point as part of the trying to sell the subdivision. And so we have been out on site numerous times, and we've had council out on site as well, and just really trying to understand how this here fits into the wider environment. At a recent council meeting, no one was really standing there saying this is an outstanding environment in terms of what's surrounding it, if you know what I mean. It is, yes, it is exposed, yes, it is on a hill, but it does not have that same Geraldine Downs visual amenity landscape values that apply. So thus we've entered into I should say Millwood Finlay Lob on behalf of Mr. McKnight has been entering into discussions in terms of, what would be the best way for this to be moving forward, particularly with the confusion between the global land use consent, which, because it isn't registered on the title, it's not like it's a consent notice that people are going to instantly see. So we just feel like Millwood and Lob feel like it would be more appropriate to just, in order for it to be easier, in order for it to be clearer, let's just have a building coverage of 12.5%, which takes into account, yes, you've got this global land use consent that will, that does sit there. But technically if you give effect to that, then have your 10% building coverage, you're looking at a 50 square metre shed, which is not big at all, very, very small. So that was sort of the context for where we got to. Is there anything else I can talk to?
No, that's great. I've got a couple of questions if you wanted to sit back down. So good. So, if I've understood things correctly, you're seeking to align what's in the global consent with the plan, the standards in the plan, the proposed plan. Are there other ways to achieve that, a variation to your global consent?
The plan change process presented an opportunity to make it easier, to make it clearer for people, and then at the end of the day, prospective landowners only have to be referencing one document rather than one document, a land use consent, potentially another consent. It was, the whole intention was for it to be consistent and clear and easier to understand than trying to massage and work together three different documents, because some people are already developing the sites based on the operative district plan. Obviously this presents quite a departure from what's on the operative district plan, so it's just a matter of really just trying to make it as easy for the everyday person who's not a planner or been involved in the site. Because if you've been involved in the site for a while, yes, the context and everything, you can follow it through, but a potential purchaser showing up, trying to get their head around the different aspects, it was our advice to Mr. McKnight that it would be more prudent to go for a zone change, a rule within the plan change process to try and make that easier.
Thank you. And have you given any consideration to any wider or broader consequences to the changes that you're seeking beyond this site?
Because this is a specific control area and it has been through a significant process to get to this point, it was our comments and our analysis are specifically centred on this zone, on the specific control area. We did not think it was appropriate to widen that out. Sorry, I did not think that it was appropriate to widen that out to other areas within the district, because the Geraldine Downs area and other lifestyle zones have been through their own journey to get to where they are. And this is definitely a specific site, a specific area within the Timaru district.
Very much. Thanks. I appreciate you talking us through that. That's good.
Ms McMillan, I understand the 2.5% increase was to accommodate market feedback. Is that right? Do we have a copy or a report about that market feedback?
Mr. McKnight will be able to speak to that in more detail, and the marketing process and the sales process for the subdivision. So I'll leave that to him.
Well, I ask because that's what's driving the 2.5% as I understand it. So I think, yes, that would be helpful. I'll ask Mr. McKnight when I ask him a question. Thank you.
Can I just ask, I accept there's some history to this matter, and you're just trying to find a solution. But it's not a unique situation, is it, that a development such as this goes through either a resource consenting or a private plan change process and results in a outline development plan, which is somewhat a bespoke solution for a particular location. It could be due to topography or adjoining activities or what have you, and then that outline development plan simply finds itself in the district plan. Is there a reason that hasn't happened in this case? Why doesn't the ODP just get picked up in the district plan as, for this location, this is the development? Why do we need to have another change and have a bespoke rule that takes things along another step in the process?
I would have expected that the Brookfield Road standards that are in the operative district plan would have been carried over to the specific control zoning, because it was given a specific control zoning for a reason. Not all of those standards were brought over, and I cannot find any reasoning as to why only 2 were. And so that's created another aspect to this, which is quite confusing for as a planner. I don't really feel like I can answer your question, actually, because I feel like that's actually the council had driven this process.
Question for council and their process.
Yeah.
That's fair, a fair response. Thank you for that. But is that an alternative to what you're seeking? Is that the operative provision should simply be carried over, or does the market situation add another gloss to it, which requires another planning outcome?
So there's probably 2 aspects to that, I would say, in terms of the process that was undertaken to get through Plan Change 20 to create that zoning. I would have expected as a planner that would have been transferred.
Yeah.
It hasn't happened. And again, I can't speak to that, but while it is appropriate in my mind that would be transferred, what that process didn't take into account at the time is the actual lived experience, the actual practicality of this on the ground. So when this district plan review process came about, we advised Mr McKnight that this would be the opportunity to revisit this matter, because it has been something that has been ongoing, that thus the global land use consent application. It's certainly something that's been realised throughout the life of the subdivision. And so, yes, I take your point. It is essentially coming in and asking for a little bit extra on top of what is already there. But in my opinion, 2.5% extra over and above what's proposed in the plan, which actually realistically is actually less than 2% by the time you take into account what's provided currently, is such a small amount of coverage that it's appropriate to allow for that in this instance, when Mr McKnight has had a very challenging time trying to manage this 80 square metre restriction. I would suggest that Mr McKnight, and I will let him speak to that, but would welcome the 80 square metre requirement being removed. Not really seeking that to go forward, but yeah.
We'll definitely get to Mr McKnight, but just working through the steps in the process. So the council has to undertake a Section 32 evaluation, as you've pointed out, to support the provision plan, and you're telling us that there's a gap in that analysis because you can't fathom how they got from the operative plan approved development to the rule that they're currently proposing. So the alternatives are what the council's proposed. The operative plan is presumably on the table to the extent that that might be somewhere similar or more advantageous, somewhere between the plan as notified and what you're now seeking. And then there's the rule that you're now seeking. So is it your evidence that the new rule is the most appropriate outcome? Or do you think that the operative plan is the most appropriate outcome?
In relation to building coverage, which is what this submission is focused on, it is my planning evidence that as proposed, it is the most appropriate outcome for this site.
As requested?
For the specific control area.
Okay. Yeah. All right. No, thank you for that, and thanks for showing us through the planning. It's good to get a real world sense of of the impact. So thank you for your evidence. And we'll now hear from Mr McKnight.
My main and really only objective is to be able to support the prospective customers in being able to house their cars, boats and whatever else that they have. An 80-metre out garage is simply not sufficient to the types of people that are tending to look at purchasing the property. So the 12.5% is just a simplistic way of achieving exactly that. It gives the prospective buyers more flexibility and the ability to either have a house or a garage with the total building area, and just simplifies the change, if you like.
And can you tell us a little bit about the market feedback that you've had? I mean, how have you gone about marketing the property? How have you received that feedback?
Well, the 80 square metres, if you can appreciate what 80 square metres is, it's not large, and most of these people do have they're not. It's not a cheap subdivision to invest in, and the people that are looking at it want a wee bit more flexibility in having the ability to house their cars or whatever they wish to do. It's the overall, it'll only affect, as Melissa stated before, a few of the sections which are flatter and don't allow for underneath garaging. The main restriction which causes that is the overall height, and part of the plan is it 3.5 metres?
4.5.
Yeah, which means you can't actually have a two-storey dwelling on there, so we can't have that under basement garaging, if you like, on all sections.
And so the properties have been on the market, so the titles are available early this year, we've heard. So I'm just not clear on what feedback have you received from the market? Is that what people are telling you? Is that
yes.
Or there's just been zero interest in the properties, or that's
No,
the
there's been interest isn't great. No arguing about that, but the people that have made some comments, either prospective purchasers or people that have made some comments of their own, are all around that ability to be able to put a reasonable size shed on the place.
Okay. All right. Do you have any questions, Commissioner?
Yes, was there a report done on the market feedback? I'd be interested in.
No, not. No.
Right. Okay. Thank you.
Well, it's just verbal, like you referred to. It's only verbal.
Oh, yeah. No, I did get that impression from you. Look, there are no other questions of you from the panel, so back to you, Ms. O'Brien.
Are there any further questions that I may pass on to Ms Hamilton?
No, I think the submissions are clear. I think it's really just a case of unpicking the provisions in the plan, and we'll obviously be keen to hear from the Council 42A reporting officers. They'll have an opportunity to give us a bit of an interim reply now that they've heard what you've said as well, and whether that changes their recommendations to us. But ultimately, we need to sort of step back and consider the provisions of the plan and line them up with what's been requested in the submission.
Thank you very much for your time.
Thank you for coming along today. Okay. I think that That brings us to the end of today's session. So we will adjourn and resume tomorrow morning at 9 a.m. Thank you.